But let's also talk about how this bill is structured and how it provides that support. It provides that support by spending over half of the money right here in the United States to U.S. businesses and U.S. workers from places like Texas and North Carolina and Pennsylvania and Colorado, all throughout this nation, who will be building the equipment and supplies that we'll be sending to our military. Because that's another important part of this. Our military sends our old equipment to Ukraine, and Ukraine uses it with great effect on the battlefield. Then the new stuff is kept by our military. So let's break this down. We're supporting our economy. We're protecting our 100,000 troops. We're ensuring a stable and prosperous Europe. We're defeating the Russian military. We're ensuring food supplies. We're updating our own military stocks. We're infusing money in the U.S. Defense Industrial Base into our own workers and businesses. And we're doing all of this for less than 5% of our annual defense budget.
Yeah, the audio is bad. All right, the audio was too quiet on that clip. So what I'm going to do, I picked the wrong thing to start with. Son of a gun, people. Yeah, let's get this out of here. I'll tell you what he just said. The Senator Cotton, whoever that was there. Hold on, it wasn't Senator Cotton. Jason Crow, not Senator Cotton. Shame on me. Well, if anybody heard what he said, it's fine. But I'll paraphrase it for you. Whatever that guy's name was, Jason Crow, Representative Jason Crow, came out and said, you see, when you're supporting Ukraine through $200, $300 billion in aid, you're actually supporting local economies, because when you give them the money, they're not just taking the aid and running and buying, Russian-made weapons. They're buying American-made weapons. And so you're employing the fine folks of Texas who make these weapons. They then go and give the old weapons to Ukraine, and they use them very efficiently. And then the new weapons get to be kept by America. And so you see, when you take your tens and hundreds of billions of dollars and ship it off for the war machine, it comes right back to America to buy weapons that are manufactured by the military-industrial complex in America, grossly benefiting those military-industrial complex contractors who get the contracts. And so you see, all that we've done is we've taken your money, your taxpayer dollars, and given it to military-industrial complex contractors. My goodness. Once upon a time, I'm old enough to remember when that was a conspiracy theory. The idea of the military-industrial complex operating as a taxpayer, tax money laundering scheme, that was conspiracy theory. It's like what people don't really realize. He's like, oh, well, we're giving $15 billion in aid to wherever. Yeah, they just turn around, give it to the military contractors in America, the Boeings or whomever, what's the one that, the Halliburtons. And they and their executives make massive profits off taxpayer dollars while, of the weapons that you manufacture, that you ship off and they go to Poland and then they get divvied up to the Ukraine, and who else knows where they end up, maybe in the hands of some terrorist organizations. That's called taxpayer money laundering to finance and enrich the players in the military-industrial complex. Once upon a time, that was conspiracy theory. And now they're just saying the quiet part out loud, screaming it from the hilltops. Oh, that is scumbag logic from a warmonger. Yep. Oh no, you're gonna employ people. You're not employing people when you pay them with taxpayer dollars. That's the house taking its cut. That money runs out. You're not employing people when you're the government paying people from taxpayer dollars. That's how you squeeze. You can't even squeeze blood out of a turnip. So that was the intro video. I'm sorry the audio wasn't good enough. And who has noticed this now? Rambo, you have to say this. You're right. How the hell can this clock be 2 minutes fast? I set this to the minute. Impeccable. Doesn't matter. You got to deal with it. That's why now it's 1 minute fast. The clock is off, by the way. People, could you ever imagine that at some point in time we would be sitting around geeking out on the internet because we're about to watch a court hearing in real time with live commentary from a madman? Who would have ever thought this would have ever been reality? Not me. I knew my law degree paid off for something. Those 4 years, it's 3 years of study, 6 years of bar school, 6 months of bar school, another 6 months of an intern. That's 4 years, plus the 13, 14, 15 years of practice. Starting my own law firm, building it up, learning the bureaucracies of operating a small business in Quebec, Canada. All of that would pay off so that one day I would look like a mildly crazy possum, but it's an opossum. And we would be live commentating, I think, one of the most, if it's not the most important lawsuit in recent memory, it's certainly the most entertaining, with a wild audience of people who are interested in understanding, want to participate in spreading awareness, or who are here just for the laughs, because there will be fanny jokes today. The poo-poo will be hitting the fanny. And if you're from the UK, that's exactly how I mean it as well. Has anyone ever seen a rhinoceros poo underwater or above water? Should I pull up a video? Should I pull up a video of what it looks like when a hippopotamus takes a dump and they use their tail to like flap that loose, fibrous poop all over the place? That's what we're going to see all afternoon. I only hope that Mr. Terrence Bradley, former business partner, former attorney, and now former friend for Nathan Wade, I hope he does not have. I don't want to jinx it. I don't want to put like bad juju out in the universe. I hope he doesn't have to go to. I hope he's not stuck at the doctor again, like he was last Friday when he was supposed to be in court testifying. It's gonna be wild today. I'll give everyone the rundown in a second. Viva, are you a hockey fan? I'm a huge one from Germany, which is why I ask. Great show, by the way. Ulf Alfred, ich bin not hockey fan. I'm not a hockey fan at all. I'm not really much of a sports fan, actually. I only get into poker, UFC, and darts, and I haven't been able to watch any of those because, whatever. So no, not much of a sports fan. I also find there's not enough time in the day. Like I'd rather be watching Big Fanny Willis have her fanny handed to her than watching sports. It's going to be wild today. I'm forgetting things. We're live. Okay, so we're live on YouTube. We're live on Rumble. Are we good on Rumble? Yes, we are. Are we also on Viva Barnes Law? There you go. Someone posted it on Viva Barnes Law. 42 posted the hippopotamus. Hold on. It's a very small GIF, everybody. This is my GIF to you. This is what I was talking about. It's the most disgusting thing you can possibly imagine. I don't even think that's in fast motion. Can you imagine being caught in the crossfire of that fanny? Oh, the dogs are annoying me. You guys want to leave? Hold on. Get up. Go. Out. Go. Get up. Oh, you don't want to go now. Okay, well, you stay there. Oh, my goodness. Damn it. Hair. It's gonna be wild today. So I'll give everybody the rundown summary. We've got 5 or 6 minutes before this is scheduled to go live. I'm gonna use the same ANF live feed, the Atlanta News Federation. I don't know. I'll use the same one I was using the last time, and just want to make sure. So we're live on vivabarneslaw.locals.com. Anybody wants to go over there? I will be paying a lot of attention to the chat there. I'm so excited. Something's going to happen. Like, we're not going to get to see this live. Someone's going to, but then if Terrence Bradley doesn't show up, okay, we'll get there in a second. We're live everywhere. Okay, I got that. We're good. Okay, boom shakalaka. Now let me go here and I'll bring these things up. Let's got my popcorn ready. Let's go, says Fried Pie. Indeedy doody. Big John, how can the politicians get rich if they don't give taxpayer money to their friends? Good question, John. They can't. Well, no, they can. Insider trading. So they wouldn't need to launder taxpayer dollars to their corporate friends, but that's another good way of doing it. You get it on the front end, get it on the back end. Like Big Fanny Willis. Okay, I'm done. Stick, $10 says, Viva, do you think the DA's office threatened Bradley with public exposure if he helped the defense? He seemed very reluctant initially. So for those of you who don't remember what happened, first of all, I think they threatened him, period. They said, remember your ethics. Wink, wink, nudge, nudge. This is how corruption works. They don't have to say, shut your mouth and be stupid and invoke a lie of a defensive privilege. They just have to say, remember your ethics. And you know what you have to do. And he did it. Terrence Bradley did it, protected Wade up the wazoo the entire time by invoking baseless privilege. And then they still crucified him. Or not crucified him, drawn and quartered him. Stuck a red-hot poker where the sun don't shine. So I think he definitely understood it was a threat. When someone says, I didn't take it, it wasn't a threat, I would say more often than not, they took it as a threat. That's why they have to say that. Coping, denial, and try to make reality. So they threatened him. And then they still destroyed him. And they were planning on doing it from the beginning because they had those witnesses lined up. What was her name? I think it was Miss Sanchez. So yeah, I think that. We got Viva must Jersey Shore fist pump during any bombshell moment. What is that? Like booyah, like that? Wait, where's my camera? There. Come back into focus. And then we got, I'm a custom leather worker and want to make you something. Email. Viva, no, I can't do it online. In the about section on YouTube, I'll get my P.O. box. And oh my goodness, they're coming in here. What chance of criminal charges for perjury? I can't feel that. I don't know. I mean, I want to see it. Viva, in the movie My Cousin Vinny, can the defense actually recall a prosecution witness like Vinny did with Sheriff Farley? I don't remember enough, but they can call their own witnesses. There's grounds to recall. I mean, the bottom line, they can do whatever a judge authorizes them to do, assuming it operates the same way it does in Canada. Like, you get permission from a judge, you can, Your Honor, we need to call back a witness. Why? Additional information came out that we weren't aware of, or we recently discovered a new fact, or something else. The judge can basically authorize anything to the extent that procedure doesn't allow for it. Okay, so hold on. Okay, we got 2 minutes. People, before we get into this, because you might have seen, did I tick off the tick box? Hold on. It contains a paid promotion, people, and it does. People, when you're, you want to avoid unhealthy habits like obsessing over Big Fanny Willis and the trial, you want to get into good, healthy habits. And most people don't know you're supposed to have between 5 and 7 servings of raw fruits and vegetables a day. Brickhouse Nutrition Field of Greens is going to get their money's worth today. If you can't get your fruits and veggies, and you should, even if you do, a healthy habit is better than an unhealthy habit. People sit back in the afternoon, you suck down a disgusting sucralose-filled Diet Coke or whatever, aspartame. 1 spoonful, Field of Greens. They're powdered greens, desiccated greens. It's actual fruits and vegetables. It's not an extract. It's not a supplement. It's a food. USDA organic approved, certified. 1 spoonful is 1 servings of raw fruits and vegetables, the equivalent with all of the antioxidants, all the nutrients. You do that twice a day, you get 2 servings of fruits and vegetables. You get a healthy habit replacing an unhealthy habit. You get the super fruits, super greens, and it tastes delicious. It looks like swamp water, I always say it, but swamp water is the root of life. And it's delicious, and it's a great healthy habit. It's easy to travel with. I actually got one right here. It's easy to travel with when you're out in a place where you don't have raw fruits and vegetables and you want to have that healthy kick in the morning, kick in the afternoon. Go to fieldofgreens.com. It brings you to Brickhouse Nutrition. The promo code VIVA will get you 15% off your first order and free rush shipping. The link is in the description. And do it. It's just delicious, and it's great, and it's fantastic. And I love them. I love working with them. And I consume it myself, although I have an unhealthy habit of eating way too much fruits and vegetables in any event. But it's just the thing you do. It's a good alternative to a diet, crappy, chemical-filled energy drink. Now, the question is this. Where is it? Where is it? Is this it? Is this it? This looks like it. We don't want to see them.
Contempt. But that could happen, right? If he doesn't answer truthfully, he could be held in contempt.
He could be held in contempt.
If he chooses not to answer,
how about he's already answered
there could
untruthfully.
Be repercussions for him, right?
Okay.
Correct. The judge and the court have resources available to them and authority available to him.
This is stellar legal analysis
civil,
right here.
Sort of component, he has the ability to imprison or put sanctions.
Yes, it's
financial
called
sanctions.
Contempt is a quasi-criminal proceeding.
Sanctions. He could hold him in contempt, of course.
Okay, I'm going to turn this off because
all sorts of things.
Hold him in contempt.
Terrence Bradley doesn't want to do that. I know that
Terrence Bradley already lied.
A good attorney.
So
he is an ethical attorney. And
he's an ethical attorney?
Be involved
they
in
just
this
accused
in
him
the
of
way that
sexual
he is,
assault the last
but
time.
I hope that he certainly, just follows the court order and does what he has to do, whether it's comfortable or not.
Okay,
Yeah.
so I'm going to.
So of course he
I'm going to turn the
has
volume
been
down. You know what? I'm
ordered
going to do this.
Show up, but to testify.
Okay, live.
If he doesn't show up, what are the consequences? If he doesn't
If he,
testify in a
it's
satisfactory
disobeying
manner to
a
manner
lawful subpoena
to
is
the judge,
contempt.
what are the consequences?
So he's under subpoena, right? The court
Disobeying
has
a
the
lawful subpoena
power,
is
and
contempt.
the defense counsel, Ms. Merchant, has used the court's subpoena power to place him under subpoena.
Subpoena
putting him
power
on
with the
notice
FANI.
that he has to be there and he has to testify, right? I like to tell people when I'm talking to them, a subpoena is not a birthday party that you get to RSVP to. It is not something that you get to choose to do or not. And should he choose not to show up, you know, the court has, within its discretion, within its power, the ability to send a sheriff's
live
deputy
now?
in a car to wherever
Okay, it
they
is
believe
live.
Terrence Bradley is, in order to pick him up and give him a ride to
What if he's at a
court.
doctor's office like he was the last time?
The penalties can go up from there and get more severe until and unless Mr. Bradley
Is the
complies with
abortion
the court
experience
order.
open at
I don't
1 a.m.?
think that that's going to be what we have here.
Terrence Bradley's
Obviously,
coming today,
we know
and
he
he's going to
doesn't
be
want to
chatty. That's
testify,
my prediction.
But the judge has made it
How are
very
the audio
clear,
levels, by the way?
what his ruling is.
We don't know what the court's going to
You know,
sound like
either
yet.
side could try and appeal that decision to a higher court if they believe
Dude, it's
that
going to
the
be
judge
it's going to
is
be
wrong or incorrect in
fireworks
his
from the
interpretation
get-go.
of the
Is my
law.
prediction.
But I think that we will see testimony today. I believe he's going to
Bring it
show
on,
up. He is
people!
represented by
Quiet
the
you on
judge as
A&F.
well.
It's enough now.
Everyone knows the rules of how this is going to work.
Hush, hush.
So
Are we-
whether or not
are we
he
listening
likes
to the right
it,
thing? Okay.
We will see, but I do believe he'll show up, and I think he will testify.
Yeah, and we see Judge
Get psyched,
Scott
people.
McAfee taking the bench right now. We see the court reporter is in. We saw everyone stand up, you know.
We did.
courtesy
This
of
is
the
all
judge,
powerful
which is
observations.
pretty typical court decorum, and that includes Special Prosecutor Nathan Wade, who we saw on our screen.
This is stellar
a few
commentary.
moments ago. Let's see if we can listen in.
Oh, please, let's do that. Okay, now, by the way, if you've come here to hear only the hearing, you're going to be better off going to another channel. There will be commentary. There will be gratuitous
Sadow
butt
on
jokes.
Zoom.
Okay.
You do, Your Honor. Good afternoon. Steve Sadow for President Trump.
Don't
We
lower
waive
it.
his presence, and I believe Ms. Little is also on Zoom.
Okay, that's right. Bring up the volume.
Okay, thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stockton, on behalf of Mayor Giuliani, I think David Lewis and John Esposito may be on Zoom as well. And we waive his presence.
There we go. On behalf of Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows, and he waives his appearance.
Thank you, Mr. Durham. On behalf of Mr. Clark.
Have we seen Bradley?
Your Honor, and he also waives his appearance.
Thank you, Mr. McDougald. On behalf of Mr. Chile.
So many
Your
people.
Honor, Richard Rice, President Court, Chris Amell.
They're the ones on trial. Not me, says Fanny.
Thank you. On behalf of Mr. Roman.
Good afternoon, Judge Ashley and John Merchant, on behalf of Mr. Roman.
Woo! Go,
On
Ashley!
behalf of Mr. Schaefer.
Greg Gillen and Anthony Lake on behalf of Mr. Schaefer, and he waives his presence.
On behalf of Mr. Floyd.
Mr.
Morning, Your Honor. Good afternoon, Your Honor.
Mr.
Chris
Floyd.
Kucherov and Mr. Floyd. We also waive Mr. Floyd's appearance.
Thank you, Mr. Kucherov. And on behalf of Ms. Latham. Anybody here on behalf of Ms. Latham? All right, I know before we'd had Mr. Cromwell.
Oh, Floyd is one of the
and
defendants.
I'd
I'm
not
sorry.
heard
I'm an
anything
idiot.
from him. I don't know if any other parties have as well, but
Your Honor, I believe Mr. Cromwell is in a deposition in South Georgia.
Let's see if I can't get better
all
audio.
right.
This audio sounds good to me.
Looked like he joined.
Okay, that's helpful to know. Mr. Cromwell, can you hear us? All right, well, we'll keep an eye on that to see if he does join us, and we'll take it up as it comes. So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know.
Oh, he's got
I'll try to
the
talk,
Rona.
close to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess the validity of his assertion of attorney-client privilege.
Oh, yeah.
I've now been able to do that, and I also allowed Mr. Wade the opportunity to weigh in and respond as well. And after considering the testimony, not only in camera, but also of what came out at the hearing.
Yeah, especially what Anna
I found
Cross
that
did.
neither Mr. Wade nor Mr. Bradley had met their burden of establishing that the attorney-client privilege applied.
Yes!
Specifically as it relates to Mr. Bradley's knowledge
Of the
any,
date of the relationship.
that existed between Ms. Willis and Mr. Wade. And particularly that it wasn't established that his specific knowledge came about in furtherance of legal advice.
Absolutely, because he was
So
bragging
having made
about
that
it.
determination, I didn't see any other choice but to allow the parties to have an opportunity to explore that topic with him. There's really, in my mind, it's that topic only. I think that there's anything else we've already covered.
The date
not
of
here
the
to do it again.
relationship and why is it
So,
critical?
With that, is there anything else we need to cover before kicking that off?
Just, Mr. Wade, he's still a potential witness.
Mr. Abadi?
I believe Mr. Wade was released from the subpoena.
Mr. Wade was released from
testimony
subpoena.
Last hearing, so unless he's been resubpoenaed, and I have no knowledge of that, he has every right to be present.
Sure. I think
He's a party. He's a
procedurally,
defendant. He
that
would be allowed.
accurate. And so, at this point, I don't see a means where he would need to be recalled. And but if it is, then that is something you can take up.
Okay,
All right.
where's Bradley?
Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway?
Oh, son of a beast.
Okay. All right, if we could call for Mr. Bradley.
Okay, woof. Bradley went for a helicopter ride. He won't be back soon. There he is. Bradley is going to be a little more chatty today than he was the last time.
Permissible to sit in the jury box?
That's fine.
Thank you.
Yeah, there would be no
All right,
need to
Mr. Bradley,
exclude Nathan
Deputy
Wade.
Scott will swear you in again.
Oh my goodness. So they're going to ask questions on the text messages which he claimed privilege over, which the judge reviewed and said there's no privilege that applies to any of this. Ask away.
Terrence Bradley, Terrence, Bradley, Bradley.
Okay. It's on.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Yes.
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, leading question.
Based on privilege.
Overruled.
Overruled.
Okay, overruled.
I do not have knowledge of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You didn't tell me that?
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you.
Oh, he's
But
had
you and I did
time.
not have a conversation about when it started. You asked a compound question.
Oh my God, has he been prepped?
Of magistrate court versus, I mean, you said it was magistrate court, municipal you said magistrate court.
Panic, Bradley.
Conference, I'm sorry. And then you asked another question. I said no. Municipal court.
Oh, she better have more
Nothing
text
else.
messages.
I'm referring to a different conversation.
Ah, okay.
I asked you, do you think it started before she hired him?
And I'm going to object, this was covered in the previous hearing.
No,
where,
it wasn't.
Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of, and actually
This is a
used,
speaking objection.
in
He's
an attempt to
influencing the
refresh his
witness.
recollection, and he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary. I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This
You
is
may.
the text I gave you. So you-
Approach the witness. Oh, you can tell that he's been prepped. Oh, that was a compound question
For
to which I
purposes
was
of the
answering.
record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered.
All right.
And I'm happy
Oh.
to tender it.
Well, we'll just take it as it comes, whatever you
We're
need.
at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach, Judge?
You may.
Okay. Yeah, when I answered that question, what I was answering was that it was not a municipal but magistrate court, but not confirming the date of the relationship having begun. I hope she has some text messages that really, black and white, confirm the dates. Mr.
All right.
Bradley.
So Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
So
And when I asked you if you thought it started before she hired him, and you responded absolutely.
I'm going to object as to the source of the information.
Well, let him answer the question
Mr.
first.
Bradley allegedly gathered this from.
This
There's
objection
absolutely no
influences the
foundation,
witness.
and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right. I think that's. Go ahead, Ms. Merchant.
I didn't ask him about the source of the
Yes,
information.
that's exactly it.
And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent fact. I can impeach him with any contrary facts.
Sure.
This is a
Why would
contrary
it
fact.
be a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So
personal
I think you
knowledge.
have to lay that foundation there, so that'll be sustained.
Do you remember telling me that it began?
Well, that doesn't address the issue.
No, I'm not. I was just asking if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't determined whether he actually knows or how he knows.
How do you do it, Ashley?
You told me.
No, that's going to be the same problem.
In fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm
Yeah,
asking if he remembers that. He hasn't answered that question yet.
Right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes sense.
This is no,
I
it
guess
doesn't
not.
make sense. This is very
Sorry. How he knows it? I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that.
Sure.
That was it.
But that's the point. It's how he knows it.
He just the lawyer just gave her a sticky to ask.
Hearsay because it's gossip and innuendo, which is what was indicated the last hearing.
Well, it may not be hearsay, it may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her, and I think we need to figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
There you go.
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times.
No, he
today.
hasn't.
said he has no idea the timeline or when it occurred.
Oh, bull crap! He doesn't.
I didn't ask when. I asked his first knowledge. He testified he has knowledge
Yes,
that they had a
when did he
relationship.
become
I
aware?
asked him when he first got knowledge of that.
I mean, the judge saw the text
Okay,
messages.
so if the question is, when did you first get knowledge? I think
Answer
we
the
can
question.
start there.
That was the question.
That was the
Yes.
question.
Thank
Good.
you. When did you first get knowledge of their relationship?
I've said over again.
Can't answer the bloody question
that
straight.
I didn't have any personal information where I could personally say
That's not what she
when
asked
it
you.
started. I've said that time and time again.
And-
So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the
They had a
knowledge. Didn't
relationship.
ask you to
You knew
comment
it.
on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection over.
He knows they had a relationship. When did he first become aware of that fact?
But he said he has no personal knowledge, so it's clear he had to gain the knowledge, not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So,
I apologize.
Yeah. When did you
When
first
did you
become
first
aware of the
get
relationship?
knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
Dude, it obviously was before.
I don't know how to answer that. I mean,
Truthfully.
I can't give you a date if you're asking for a date. If you're asking me, how did I get the knowledge?
That's not what she's asking you.
It would have come directly from my client.
Right.
So help me understand.
Oh my God, this
so
is
you can't
pathetic.
answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
Nobody believes you.
Next question, Ms. Merchant.
But you don't know the specific date.
No.
Do you have
Do you
a rough
know
idea?
Can we narrow down the timeline?
Yeah, 2022?
Did you gain knowledge in 2019 of this relationship beginning?
Ooh, that's a
I'm
good.
gonna object
Don't
to
you
Ron
shut! You
Quickly.
shut.
He said he does not know when he gained
All right.
knowledge.
He doesn't know the specific
He's
date.
narrowing
Fine,
it
Ms. Merchant.
down.
I think I'm overruling that. I think we can try to see if he can narrow it down based on.
And by the way, that lawyer who just objected basically told him what to answer now. There you go.
19, I would probably say no. I mean, I don't have anything that
It's very irritating.
there wasn't a specific date. There wasn't a football game. There wasn't something
not what
that
she
I
asked you,
can
although
attribute
maybe they have a text
to
message.
him telling me whatever. And so you're asking for a date. You're asking for a year. It's still a date. And at this time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
That's the
Can I
taint
see
review? Is it the taint?
Yes, I think so.
Exhibits are, I think, okay.
The first
I
appearance.
think if it was from the exhibits, I think it was 21, yes.
And I don't want to belabor the point. You submitted those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time
Yes,
said January 2022, that's, okay.
21.
I'm sorry, 21, you're right, thank
And
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Objection. He's going to say, I don't know.
Of 2022,
January 25th, 2022.
guy didn't object?
2021, I'm sorry. When you got your first contract?
Bullshit, you don't know. Yes, you knew that they had a relationship at that time. Cue the music,
I
people.
don't recall.
I don't recall what I
don't
knew.
recall any specific dates.
I don't recall. Say the line, Bart. Say the line.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly, it was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm
correct?
going to object, Your
I
Honor.
can't say that.
Characterization of what
Wow, he
Mr.
really has
Bradley
been.
just
He really
said.
has been prepped.
Just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or
Did
tie
you
it
know
to
that you had a
some other event
contract,
that he
a
might
relationship
remember.
at that
I agree
time?
with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked
right.
and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question. So, what's your next one?
They better have some
And
documentary
Judge,
evidence.
I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked
Please.
me about him bringing me a contract.
She better have
I
a
said
text.
he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
You knew her through the business. So you had met her prior to your contract?
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now, and so I'm trying to create a timeline to hopefully piece this together.
All right. Well,
This is bullshit, by the way. Just you're right, country girl.
I'm not saying really that the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that
But
you're
what
going
are
to be
the
able
texts?
to create one today.
What are the
Thank you.
texts that the judge saw in camera? She had better, says B. Walker. Surely she has the texts or something to stain. What did the judge review
So
in
the time
camera?
that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes.
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
He really is answering the
rarely saw
questions
them
for him.
together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through Well, actually, no. If he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong.
Knowledge that was conveyed to him by
Somebody else. That he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
Okay, he just helped her there. The knowledge conveyed to him by somebody else was not privileged. Who was that somebody else? When did Nathan Wade...
Do you remember telling me that not many people knew where they met?
She's going to have the same objection to that.
As to relevance, as to his personal knowledge, which is what 602 requires.
When did Nathan Wade tell you that he entered
His
into the
personal
relationship?
knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
that would be the next question. But
Ask him how he knows it.
I first have to establish that he said that.
No, the judge just told you.
could go the other way around.
Ask it. Don't laugh at the judge.
When you told me that it started when she left the DA's office and was a judge in South Fulton,
How did you know that?
where did you gain that knowledge from?
There you go. From Nathan Wade. Because he doesn't get to claim privilege anymore.
I'm going to object because his testimony a few minutes ago is that he did not recall making that statement.
Shut up with that objection.
Answer the question if you can.
Who told you? Nathan Wade.
Repeat the question.
Oh, yeah, I forgot the
When
question,
you told
too.
me that their relationship started when she left the DA's office and was a judge in South Fulton.
Who
Where did
told
you
you
obtain
that?
that knowledge from?
Objection hearsay. Objection privilege. The lawyer's thinking of an objection right now. The other one there.
It was.
I made
was
it up.
Speculating.
Bullshit.
I didn't have a.
Where did you get it from? Did you make it up? Where did you get it from? I would be.
No one told me I was speculating.
No one told you that?
No one told me that.
You were speculating based on things that had been told to you?
Oh
and
my
you have
God!
said?
I was speculating.
I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew.
I was just speculating. Just made it up.
It's inadmissible for this.
When
All
did
right,
Nathan
the
Wade?
motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge.
Oh my goodness.
Was this speculation, when you told me that, was that based on
What Nathan
things
Wade?
that had been told to you and things that you had witnessed?
I never witnessed anything.
That's not the
So,
question. Who told you?
It was speculation. I can't tell you
Where it came
anything
from?
specific.
No, I
if that's what you're
just made it
you're
up.
asking.
Just made it up.
You can't tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean,
No, it's 1
don't
year ago,
recall,
dumbass.
but No, I don't.
Did you have any reason to lie?
Oh my goodness. I wasn't lying. I was just making something up.
I don't know if speculation is lying, but
Well, let me just, show me where in this text it says you're speculating.
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here. that
No,
this is speculation.
Where
if
did
this is the same one that you just showed me, it does not.
did Nathan Wade
You're
ever
welcome
tell
to
you?
to look at your text.
This is too much.
Is there anywhere in here that indicates that you didn't have knowledge of this
No.
relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. He's explored that. He said it's speculation, and he
This lawyer's
didn't
really
give any
testifying
source
for
other
him.
than his own speculation.
Sure.
So
I think we're fleshing that out, and I think it's her right to have a little leeway on this if he's.
I just
adverse
made it up.
witness.
You didn't ask me if I was making it up.
These speaking objections are clearly coaching.
There
witness
you
because
go.
He's regurgitating.
Finally, Ashley. I've been saying it for 5 minutes.
comment, I'm objecting based on the law.
No, you're not. You're telling the
Making a
witness what to
record for the
say.
court. So I take offense.
Take offense all you want. A
It's not
stuck
the
pig
case.
squeals.
All right. Well, I think we can start with
A stuck
objection,
pig
the grounds
squeals.
and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
There you go.
Objection, hearsay.
Nathan has testified. It's
Yeah.
not hearsay.
It still
Well-
hearsay. It's an out-of-court statement being brought in for the truth of the matter.
No, she's not bringing up the truth of the matter. She just wants to know what he said.
Yeah, this would be for impeachment by contradiction, which would be an exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
There you go. And by the way, I've been very good. I
think you just overruled the privilege.
I called those speaking objections a long time ago.
So we've already established that December 2018 was the date of the privilege.
Sure. And that's something I covered in the in-camera hearing. And I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
It says Viva's on
And Judge,
fire
I
in
just want for
French.
the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is
There you go.
looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting
And he's
somehow
taking a long
in the
time
court.
to
So I just want
object.
the record to reflect that, because it wouldn't otherwise.
It's there now.
Thank
Do you have a question was put to you, Mr. Bradley?
Judge, one of my lawyers is sitting right in the back, that's behind.
Why is Nathan
Look
standing
wherever
up?
you want.
Yeah, and I'd never looked at Mr. Wade or his attorneys. That
Well-
sounds true.
Why is Nathan Wade standing
Mr.
up?
Bradley, question was put to you.
Repeat the question, please.
Yes.
After-
So
after
I
the
showed
speaking
you,
objections.
Or I asked you, I'm sorry, the last question I asked you was, what did Nathan Wade tell you about the relationship?
What
Same
did he?
objection, Your Honor.
And that's already been
Overruled. What did he tell you? I don't remember. Can't remember.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back
Overruled.
of our office.
Overruled.
Our offices were the only two in the back. There was no one else present.
This has
That
been
is all
overruled.
I can tell you at this time.
Made in confidence, and I can't remember. So you remember that the confidence was relevant?
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's
Testing credibility.
Clarify for a thorough and sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
She better have something black and white on paper.
Okay. So you talked about this one time, and you said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not
Can't
recall.
remember.
Okay. And how did it come up?
Say again?
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing.
I remember where
prior
it
to
occurred.
that.
In confidence, but no idea when. Just the last 3 years have been a total blank.
Did you receive an email from me on January 6th?
Of what- of
with
what
a
year?
motion attached?
Of what year?
I think I did. Yes. Yes. I know. I received a.
I think I
don't know
did.
if the date is January
I know
6th,
I
but
did.
yes, I received that.
Okay.
Yes.
So you remember receiving that?
Yes.
The date, okay. And you reviewed it, and then you and I spoke about it? You recall that?
I don't remember that.
Did we speak over the phone, or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking-
remember
How we communicated about
whether it
it.
was text to phone or
Oh my goodness.
But you recall us speaking, one way or another?
one way or another. Yes.
Okay. And where I was trying to confirm the facts in that filing.
think
I don't know what you
remember,
were trying to do, but
there was a line of about the accuracy of how much money that my office, the law office of Terrence A. Bradley,
guaranteed you there's something
had
else
received.
in there as well.
And whether or not that was going to be in the motion or not.
Well, there wasn't a discrepancy. I had kept that out, and you asked me to put that back in, correct?
I recall you, that may be accurate, yes.
That might be accurate, yes. This is 3 months ago.
Be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy, because the accuracy was that I received, I had a contract and received 74,000.
74,000.
And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount. But there was not anything in there originally, and I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's correct.
Because you did not want anyone knowing that you had talked to me.
Damn good question.
I object this for relevance.
We bias. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
And it's impossible.
Okay, so that was your interest was in accuracy in the file.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that that I'm going to be in your motion.
Right. I asked you to review it for accuracy.
For accuracy, and I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about your salary, or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put the firm, the money wise. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I
Correct.
did. I did put it back in, and I sent it to you again.
I don't recall getting a second email from you now.
But you were happy that I put it back in, or that I agreed to put it back in.
And object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise.
By the way, I just tweeted out this question, and in the hopes that Ashley or someone
so you
might
asked me,
see
you did
this.
ask me to put that back in.
Well,
And answered relevance.
well, he didn't answer that last question, so overruled.
You asked me to put it back in. I don't
You did.
remember. I don't
Can you
remember what I
confirm
asked.
You did ask me to put that back in.
I don't remember what I
Or
was
to be
thinking.
accurate.
Yes, that's correct. I said that, yes.
And then I asked you if everything was accurate, and you said, looks good. Correct?
I recall you asking that, but the looks good was
About
applying to the accuracy of the 74,000. That's it.
Okay.
That's a
So when you
very
reviewed the
prepped
motion,
answer.
and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion, though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says. But I did my saying that it
That's
looks
okay.
good was
It's only that
when
one
you put
paragraph.
back in the 74,000 into your motion.
Nothing else.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion, though, right?
But I didn't state that anything was accurate other than
that one thing.
the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
Oh,
May I approach, Judge?
You may.
Which page are you showing?
They're not page numbered. It's January 6th. Yeah, of course. I can show you just all the text.
I'm going to get to the super chats and rumble rants and tips afterwards. This is frustrating, everybody. This is why it's. I get the feeling the judge has seen the texts. Presumably, there were texts between. Oh, maybe she didn't have any texts between Nathan Wade and Terrence Bradley. She only had her texts, which they were objecting to on privilege, to say that he had no business telling her that because it was all privilege, and all of a sudden now he can't remember. It went from privilege to I can't remember why I said it, and I made it up out of thin air. And when I okay, Shut my big mouth
We
now.
had been talking and you asked me to send you a rough draft and I told you, okay, but I didn't want it to be leaked before I filed it.
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
If you say so. Yeah, now you know why they destroyed
Yes,
it.
that's correct. Yeah, yes, that's correct.
Took a
And
long
that
time
was
to
at
get.
10:08 on Saturday, January 6th. And then you got an email from me with that rough draft at 10:25 that same day, correct?
If you say
Yes.
so.
You need to look at it.
If it says 10:25, then I know you sent me an email.
While he's looking at it, I'm going to object us to ask the name. We've been through the fact that he sent him a copy of the motion.
Speaking
whether
objection.
He specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I object to ask the name. So.
Understood, Mr. Vaughn. We're getting there. Overruled for now.
And then I responded, when we were talking about that footnote that we were just talking about, I said, I took it out, but I can add it back, and you said, yes, add it back. You remember that?
I answered that, yes.
And then I said, anything else, anything that isn't accurate, and you responded, looks good. You recall that?
I was just talking about that one paragraph. I was talking
Let me
about.
see the.
Of course.
And there, I don't know where the exhibits are.
Oh my goodness. What was I about to say? Yeah, the lawyer for Terrence Bradley is really.
Refresh your memory?
It says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
But that's not what this says. This says, you said, yes, add it back, and then I said, anything else, anything that isn't accurate, and you responded, looks good. So you weren't responding to put it back in.
Your Honor, I'm going to object.
I
This
know.
is not his motion. He wasn't the affiant of the motion or verified the contract.
Overruled, Mr. Body.
Talking about his personal knowledge.
I've said
No personal knowledge.
twice.
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
Do you remember telling me about Nathan and FANI coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know Miss Willis was there, Mr. Wade was there.
It was at our office. Actually, Miss Willis was there, and there were other people there. Mr. Wade was not in that meeting. He was in the back.
He
I
remembers
wasn't
all
even
these
in that meeting.
details.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, let's back up a sec. So Ms. Willis rented a law office from the Evans firm, or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
No, I'm going to object to hearsay.
If
Well,
How does he know the information? That would be the correct question.
okay. Ms. Merchant?
I don't really know even how to respond to that. Hearsay, I'm asking if he knew that she rented
Yeah,
office space.
he may have been there. He
Right.
may have seen
Well,
the
but
business
meanwhile, that
cards.
lawyer just told him what the lie is going to be.
I've never been
I don't
to
know. I've
Ms.
never been there.
Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was.
So if I said something, it's from what someone else told me.
Do you
Hearsay.
remember, though, knowing that she rented an office
Yes.
from the Evans?
Yes,
You did know that?
that is correct, yes.
Okay. And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
Objection. Rendezvous.
I'm going to object.
Rendezvous is such a
Again,
dirty word.
hearsay as to how he knows that information. He said he has no personal knowledge.
Testifying for the witness. Shut up, lawyer.
He answered it.
No, he said in general he had no
In general.
personal knowledge.
Oh,
It's not been
the
established
judge had better
source
sanction
of
this
how
guy
he would know
already.
this because he
He
said
won't,
he's never
but-
been to her office.
All right. Ms. Merchant, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, that a speaking objection.
Speaking
and so
objection.
now I would anticipate what our response is going to be.
Yeah,
next.
it's going to be, I don't remember.
I didn't.
I heard it
ask
from somebody else.
Anything that was objectionable, but these objections are
Coaching the witness.
The witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if he knew.
Well, no, you're asking if you had knowledge, and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came from.
all right, well, let's try again.
Yeah, let's try again.
So
But now,
my
now
question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge.
Do you see
if
this? He's been.
what
That's
you're
just.
asking.
No, that's
I didn't
not.
ask that yet. I asked
Knowledge.
if you have any knowledge.
But
Objection, that would be hearsay.
Overruled.
Overruled.
What if it
We
came from Mr.
don't know
Wade,
where it
Judge?
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have
Prep
received
answer,
would
prep
have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked.
that was actually a very good,
What
big
did
answer.
you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you
Uh,
ask.
Overruled and sit
He's
down and
already-
be quiet.
He's already asked the next question.
Overruled,
Can you
sit
repeat
down
the question?
and be
Yes.
quiet.
How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what
Exactly.
Mr. Wade told you about Miss Willis and Mr. Wade meeting at the Evans office.
Objection, hearsay.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Overruled. He saw the texts.
Overruled.
He told me. Hearsay. Okay, well, I'm not saying it's true what he told me, but he told me.
You recall the question, Mr. Bradley?
Nope.
I do not.
You re-asked the question, Ms. Merchant.
What did you learn from Mr. Wade? I was clarified that's where you learned it from. About
Good.
Mr. Wade and Miss Willis meeting at the Evans office.
Get it.
Together.
Get it. Answer the question now. It's a bit of a compound question. I would have simplified it, but
I don't object to asked and answered. He's testified that.
He hasn't answered.
Shut
We
up!
haven't heard an answer.
He testified he had one
But-
conversation. with Mr. Wade,
objection.
lack of-
Get the witness out of the room if you're going to do
law.
this.
No, and his answer may change. So
This is
overruled.
As to what, how to answer the question.
You just told him how to answer.
I can't recall what the conversation was.
This is terrible.
I do recall
He told me.
knowing that that he would go down to the
High five,
office
high five.
or had been down to the office, but I can't tell you in what capacity or when or any of that. No.
Mr. Wade told you that they had sex at the office, though, correct?
Objection. Very
I don't
personal.
recall him
Embarrassing.
saying that. No.
You don't recall it.
No.
So it's possible he did say that.
You don't recall him saying they had sex at
You
the
just don't
office?
remember one way or another?
I do not remember him saying that.
And
Someone just
do you
sighed hard.
recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener.
That's not
I've
what she
never
asked you.
been to Miss Willis's house.
Not asked.
I've never been.
Those weren't the
to-
questions.
And I'm trying to
No,
explain.
no, you're not.
I've
Don't.
never
Nobody needs an
been-
explanation.
So no, I do not have any personal knowledge of him having a garage door opener.
Let me ask the question again.
Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source
That he had a
that
garage
he
door
had a
opener.
garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, not. No, I don't have any knowledge.
So when you told me that, did you just make it up?
Do you have something that shows that I told you that?
Yes, well, we're going to go through all the texts we can, but so was that made up, though?
But I'm going to object because
I don't recall him having.
Mr. Riley, just
I'm
a
going to
second.
object under 106 as the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But, I mean, if I'm asked to qualify exactly where that's from, I would give
Okay,
it.
so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have-
next step.
And that's what I was asking him, if that was something he just remembers making up. If he doesn't, then that's fine. But
Well, no, but then show the
Started
text.
to go into her packet of papers.
Sure.
and have text
So you don't
messages.
have a text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And I'm-
he has now said that he has no knowledge, so on to your next question.
Okay.
Yep, unless you can disprove that.
Did Mr. Wade tell you about the trips that he and Miss Willis took?
No.
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Wrong. It might have been in scheduling. They work together.
I do now.
Okay. But you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay. And when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words though, right?
I'm going to object as to relevance. He said he did not know and he actually learned from Ms. Merchant the information.
He said he learned about
She'd better be
certain
able to
trips.
find a text or something.
You
Someone,
can tie it down, but
Thank
someone
you.
had better be looking
see.
for that.
No
Yeah.
information about any trips that Ms. Willis and Ms.
Testifying for the
Wade
witness.
took, that he learned it all from Ms. Merchant. That was his testimony.
sure.
Judge, I'm
Maybe
allowed
the conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if, Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. Do you remember that?
I don't recall that, but if I don't recall.
Oh my
Judge
God.
Naprich, it's
Sure. You may.
in one of the ones I gave you.
Well, at least she's got the text here. Hopefully she goes back and finds the other text about the clicker, the garage thingy thing. I don't recall telling you something so specific about a piece of information, so detailed. I don't think she's blowing it. Fornication. Oh, I get what your name is. But yeah, she...
Look at that, let me know if it refreshes your memory.
Yeah, I mean, why she wouldn't have all of the texts? Unless she didn't have the text and it was just a bluff. But
So when that,
oh, so now he remembers.
So just first let me know if that refreshes your memory.
yes,
Okay.
yes.
So it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off, and you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yes, you did.
And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone, or whatever refreshes your memory, you said was after you left, after the firm was dissolved,
I'm
correct?
going to object to relevance.
Overruled.
It was after the firm, the trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Is it easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not, so you're
would that be easier for you?
You can just provide the documents.
Okay. Let's see.
May I have some water, Judge, please?
Yeah, let me see what we can do.
Sorry, Judge, I'm just trying to pull out all of the messages that you may need.
All right. Well, I don't really see, some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
Okay, I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. You told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one that typed Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
Obviously, and I'm not asking if you went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
You told us last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance over here today.
Well,
he
I
just
think this
answered.
was going to be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card
I
before.
object to asked and answered because it was covered during the last hearing where he acknowledged that Mr. Wade used his credit card.
Judge,
So,
I asked when.
just
I didn't-
when, okay?
I didn't ask, did he? I asked, when did he?
Let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business, and that throughout the business, we would order paper or supplies or filing of depositions. The cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did, but I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
But he used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
And he paid you back in cash.
I never testified that he paid me back in cash. I said that he would either pay me back, I said I couldn't remember. I do not recall. Sometimes he would write checks. Sometimes he would pay cash.
I thought
that
he
still
was-
applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
And this was when you were still, before your partnership split up, correct?
It would have been before I left the firm, yes. He wouldn't have used my card after I left the firm.
Okay, so we can at least narrow down the dates to that.
Of before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
Objection. Asked.
That's
Answered.
incorrect.
He did not tell you about that.
He didn't give me details.
Oh my goodness.
He did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
I don't recall. Oof, let me see here. I don't want to get killed. I don't want to get audited. I don't want to get pulled over on the way home. Nah, so I'm going to have to go with I can't recall.
At this time, I don't recall.
So what can I do? I'm trying my best.
No, I don't recall.
Where did you get that information from then?
It's justified he doesn't recall if he even had that information.
Oh, that's not what he said.
If he got it from Mr.
That's
Wade,
not what he
and
said.
Says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
Okay.
I
And
she
you and
better
Mr.
have
Wade were
some
friends as well as
hard
business
evidence.
Partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Mr. Chopra. Oh, that's his attorney.
Was it after that?
Who are you looking at for the answers, sir?
So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when
Bunch of
I
random details.
received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present.
What the hell are you
Mr.
talking
Graham,
about?
I called, and I had started getting calls from media, and
Can we just call this guy Abe Simpson, like Grandpa Simpson? Just
and I told him to respond to the media, I think, and that was somewhere around whenever you subpoenaed me. So
What
it
the
was,
hell
I
are
can't
you
tell you
talking
that it was that instance of those calls for Mr. Chopra. But I had engaged Mr. Chopra and Mr. Graham at that time.
Okay.
what did you just
I'm gonna ask the
answer?
question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your
I
friend,
think it was before that, but however,
Can't recall,
I think
though.
it was before that, is what I'm stating.
when you got the phone from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
Wow, that's pretty. That's pretty
didn't call
wild.
you immediately.
But I called you.
But
The
yes,
same day.
we did speak.
Okay. And you texted me about it as well.
That is correct.
And
His life just flashed
then
before
we
his
spoke
eyes.
after Mr. Wade called your friend, and we talked about that as well, correct?
Yes, ma'am.
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or, that is correct.
Yes, that was only my question. Let's see. I'm gonna show you two more texts that are in the one.
Damn, better have some
All right,
darn.
Ms. Merchant, we're going to do
This is the
5 more
last
minutes.
two questions. Thank you.
3:05, I'm cutting you off.
Thank you.
Hopefully somebody else has got something concrete. A little disappointed. Little disappointed, people. That's a beautiful picture. Life, it finds the way. Although that flower would have been stepped on.
May I approach? I'll show you full text to refresh your memory and then one.
Yep, bring on the Trump attorney. Ashley's done a great job, so we can't criticize her. But now I'm just wondering, so the judge only reviewed the text messages between Ashley and Terrence, it looks like. So they didn't have any other text messages. Couldn't they have compelled him to bring text messages in the subpoena? correspondence, emails.
Are these supposed to go together? Oh, these are two separate dates? Okay, all right.
Okay.
So I know we talked about the other occasions where you said the texts were just about the footnote. But do you recall me asking you, do you think it started before she hired him? And you said absolutely.
Would you
recall that?
objection asked and
I
answered?
see that in the text message, yes.
Ah! I
And,
see that I said that.
Do you also recall me asking you how they would react if they would attack me? And you said, no, they will deny it.
Your Honor, objection as to speculation.
That's a speaking objection.
How he thinks they
He's
will
telling.
react.
I think it goes to the motivations of the witness.
He's telling him. I don't
And
know
you
what.
told me that they will deny it.
I don't know what they would say. I was
That's
speculating.
written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today?
I am.
Is there any of your testimony from today or the previous days that you want to correct?
I don't recall.
That I want to correct?
Yes.
Huh?
No, I told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so co-counsel and the state can have them, just for the record, I can admit those few that.
I'm just waiting for the
Well, they
movie
weren't ever
scene. Like,
tendered,
And
so it's just for.
I didn't know if they wanted to
Right.
use them, but I'll hold on to them.
just
need to be
one
tendered
more
at some
thing,
point.
Mr. Bradley, if that is your real name.
Let me turn over to Mr. Sadow.
Okay,
With us
Sadow.
on Zoom.
Come on, Sadow. Oh, he's
Thank you,
not
Honor.
there.
I do have a few questions. First thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time. We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
Okay, this is sounding good.
All right. We can try to work through that logistical challenge. This is, you said 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
Okay, because
I can do it.
that's where I want to. That's where I'm going to start, but I'll see what I can do to work.
This is the guy that was yelling at Fannie Willis. I'm joking. Bada bing, bada boom.
Here, I'll email them to you.
Stop yelling at me, Mr. Sadow. Would someone please think of Terrence Bradley? Okay, someone's got to have something black and white. How much? Oh, Sadow, maybe.
All right, Mr. Sadow, why don't we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right.
Come on.
Mr. Bradley,
Yes, I'm here.
all of a sudden I've lost you on the screen.
Okay.
There we go. Well, you're on the Zoom.
Boomer.
You're on YouTube, but you're not on the Zoom itself. But
Oh, so
I
that,
thought I can see.
that means he's watching YouTube in real time.
I'm here. I can hear you.
No, I know. I think his visuals may be a little different. So
That means Sadow is
Mr.
following this on
Sadow, we
YouTube.
could try to correct that. So that I was-
Yeah, he was on. He was on when Miss Merchant was asking questions.
We need to
Be
add.
able to see you.
I know. We need to add a spotlight to to the witness stand and a spotlight to Mr. Sadow. We don't need all the other boxes.
There we go.
All right.
Thank you very much.
Well, then hold tight, Mr. Sadow. We need to add you as well.
I don't. This whoever said boomer. The joke is I don't think it was Mr. Sadow's problem. I think they had like reached their capacity on Zoom. Maybe. There you go.
Now we're ready.
Now I see the witness.
Thank you, sir.
I want to see the.
Mr. Bradley, you have referred to Mr. Wade as your client, correct?
Correct.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
No, I'm aware that the court ruled that
The text messages between me
one
and Ashley.
specific dealing with the time frame of one specific conversation wasn't privileged.
then I'm going to ask Your Honor, if it's that the limitation, or
Excuse me. To clarify.
email.
Sure. Mr. Sada, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling. The only ones that I deemed were not covered, and that I'd asked
Establishing
about in
the
the
date
in-camera
of the
hearing, because those are the
relationship.
ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I understand. So, going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Repeat the question, please.
Yes.
Okay. And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regard to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented
This is
Mr.
the
Wade?
question. This is good.
One conversation of what?
Oh, he's
I
got.
apologize.
Yeah, apologize all you want.
The only thing I'm asking about is that area that the court said is not privileged.
You
which is
represented
the
him for
relationship
3
between
years?
Mr. Wade and Ms. Willis.
And you had one conversation?
You've testified that during the time you represented Mr. Wade,
Yes.
from 2018 on,
Bring it, Sado.
that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade.
That was
Is
your
correct?
testimony, correct?
Yeah, I think that's fairly accurate, yes.
Okay, so out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021, when did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate
Date,
time.
2022?
I left maybe June, July of 2022, maybe.
Okay, so that would suggest that for, assuming it's 2018, 2019, 2020, 2021,
Yes, say it out.
and half of 2022, which is
Four
in the vicinity of
4
4 to
years.
4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms. Willis. Is that correct?
Bring it, Sado. Under oath. Perjury.
I
Disbarment.
don't recall having any other conversation with Mr. Wade about him and Miss Willis.
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation besides the one?
I'm going to object us to ask and answer.
Yeah, you can sit down and be
Drilling
quiet.
down. I think that's a fair question, overruled.
I don't recall. I would say it was the one, but I don't recall.
This is damn good.
You testified that you did have communications with Mr. Wade about him visiting with Ms. Willis at a condo or apartment, correct?
Look at the pen.
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Say it again. Convince yourself.
Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
I do not know when the relationship
That's
started
not what he asked you.
between Mr. Wade and Miss Willis.
Not what he asked you.
I cannot recall
so
that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Drill down on that.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
November 2021.
I have my contracts to show when I started. No one showed me the contract of when he started, but
That's my
but
understanding.
If he has a contract for November 1st of 2021, then that's correct.
All right. I'm going to I'm going to suggest to you that the record will reflect that the contract between Ms. Willis and Mr. Wade was November 1st of 2021, correct? I want you just to accept that, okay?
Objection. He doesn't have to accept
Is it
anything.
your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Ms. Willis
As
before
of
the contract?
November 2021. Listen to this.
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall any specific date that he flat out said anything about a relationship with Miss Willis.
Okay. Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. Okay? In Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Ms. Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Ms. Merchant, like just date, don't hire him. Do you think it started before she hired him? You see that?
See, this is good. Not to compare it or poo-poo Ashley. This is good. One conversation in
Yes,
4.5 years.
Yes.
And your response to that was absolutely, correct?
I'm going to object, asked and answered in cumulative.
All right, so, Mr. Sato, I do think we went through a lot of these texts.
Oh, you better wipe that sweat down.
We didn't
Whose
go through
phone is that?
this whole one.
Just a second, Mr. Sato.
Shut that phone off.
All right. I'm sorry, Mr. Sato. Well, you said we didn't go through this particular one?
No, we stopped right there. I want to go.
I answered because this
So
is the exact
re-
language that she
repeat
just
your answer.
stated a few minutes ago. You could read it back.
Okay,
In
Mr.
the
Sato.
record.
You're saying both of these 2 exhibits weren't already covered by Ms. Merchant?
Not,
It was
not thoroughly.
this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now moved into evidence defense exhibit number 26.
Okay.
All right,
What is
and
it?
I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
It was.
No, it was only presented to your honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay. Ms. Merchant is indicating that it was admitted.
I thought Mr. Sadow admitted it, but I'm organizing and putting them back in order.
This is why it's good to have multiple
I
turns.
just admit the copies of the
All right.
documents we're all referring to.
All right, so Defense Exhibit 26 and 27 are being tendered.
Well, actually, only 26 at this time,
Okay, Defense Exhibit 6, any objection from the state?
but 26.
26.
This is a portrait of justice in action.
I'm going to object as it relates to foundation and authentication. It
Oh,
was
shut
used to,
up. Listen to him.
During the last hearing.
Listen
for
to him lead the
purposes
witness.
of, refreshing his recollection, and it's my recollection is that it didn't refresh his recollection.
Oh, that's telling the witness what to answer.
Asked and answered in cumulative.
Okay. As to foundation and authentication, I think Mr. Bradley has recognized them as texts that he sent and received.
How does
so,
the judge let him get away with this? I don't know.
I think I'd overrule on that basis any other objections to their admissibility from any other defense counsel, and seeing none. Defense Exhibit 26 is now admitted. Mr. Sadow.
Testify.
Thank you.
Bring it.
All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton. They met at
Let him finish the question and be quiet.
All right, understood, Mr. Body. I'm going to let Mr. Sadow have a few minutes on this, and we'll go from there. But
Judge, I'm sorry. I did answer this. I answered it for Ms.
Understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
All right, well, thank you
when
for
I
that
said that
recap,
I
Mr. Bradley. Mr. Sadow's
speculated.
asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So, Mr. Sadow.
You said
All
it.
right, I hesitate to have to start back where I was, but
Do it.
after the word absolutely, you on your own said it started when she left the DA's office.
I made it up.
And was judge in South Fulton.
I made it up.
They met at the municipal court CLE conference. That's what you said, correct?
CLE is continued learning education.
It's your
legal education.
testimony, at least so far,
That you made it up.
that when you on your own gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade.
Who
Is
believes
that your
it?
testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part, correct?
Overruled.
Overruled.
That's
Shut
no
up,
questions,
lawyer.
Riley.
Yes, that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question.
No,
I was
it's another one.
speculating To
It's another one.
The answer. That is correct.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton?
Because I was just trying to be helpful.
Why would you speculate and say that in a text?
I was just trying to be helpful. I thought I'd be helpful.
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
I
Objection,
answered
asked and
that
answered.
At the last.
Answer it again.
I'm
I knew
asking
that.
you now.
How did you know that?
because
I'm
when-
asking you now.
Ask-
I'm asking you questions, and you are in a situation where you get to give answers.
Mm-hmm.
I'm asking you, how did you know that?
Stop. Just let him answer.
How did I know when they met?
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who?
Who told you?
Mr. Wade told me when they met.
So
Bammo!
you had more than one conversation about the relationship between Mr. Wade and Ms. Willis, because he told you where he met her.
That's
correct?
incorrect. Incorrect.
Oh, okay.
It's incorrect.
It's incorrect.
When did he tell you that?
Let's go back to the exhibit.
Toast. This is toast.
Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
I don't recall, but why I thought that it started at that time.
But you just said he told you.
I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her.
Did you
correct?
not? Yes, I did.
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade
Was because she was preparing.
she was trying to show
proceedings.
when the relationship began, correct?
That's correct. Well, I don't
no,
know.
that's
I don't know
not.
what she was thinking.
100%
It's not. Look at the
correct.
beginning of the text message.
Sada's crushing it right now, in my humble view.
Yes, but what
Text message-
messages were before this message, before she sent that?
I can't answer that question because I don't have them. All I have is what's in front of you.
Yes.
And it says that she says, do you think it started before she hired me?
Yes,
So you knew,
definitely.
as the counsel for a defendant in this case, that Ms. Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Ms. Willis, correct?
I mean, based on this, yes, I see what
And
was asked.
in response to that, you answered directly on your own what you now claim to be speculation.
Well, he just
right?
confirmed that Wade told him. I thought he
So I
confirmed.
ask you one more time before I move to the next part of this.
Mm-hmm.
Why would you speculate when she was asking you a direct question about when the relationship started?
I just wanted to be helpful.
I have no answer for that.
Oh!
Except for the fact that you do in fact know when it started, and you don't want to testify to that in court. That's the best explanation, isn't it?
This is a
Overruled.
Overruled. Be quiet, lawyer. Don't tell the witness what to do.
That's the true explanation, because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that again. But if you didn't know, and you were asked specifically, as this exhibit shows,
why?
Maybe you can explain why you wouldn't say, I don't know.
Saying it a lot now.
Is that a question?
Yeah.
You're asking me a question to answer?
Definite question.
Why didn't you say?
State that again. I apologize.
Ah!
If you're being asked,
Lawyer's going to
as we've
object.
just gone through with this text message from Ms. Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said
I don't
in
know.
response, I don't know when it started?
I don't know why I didn't say I don't know.
Ah! I don't
Maybe,
know
again,
why
it's
I
because
didn't
you
say
know
it.
what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
Someone's going to have to clip
No, I
that.
can't sit here and tell you that what you just stated was correct.
I don't know why I didn't say I
What
don't
you
know.
want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own to simply speculate and put it down in a text message, as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
I don't know why I said it. I don't know why I didn't say I don't know. And I can't remember
That
why I
was a
didn't say it.
lot. So can you break that down? I apologize.
I apologize.
You're asking me, do I want the court to just
To believe that instead of saying nothing, you decided on your own to speculate.
Yes, I speculated. Yes, I've stated that I speculated. Yes, sir.
That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that,
He did just say he got specific information from Wade.
you see, it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says, that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at my opening line says in South Fulton. Is that on your second page?
No. So if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up on whether it starts that way. Does the second page have a line in there that says in South Fulton?
In West South Fulton, born and raised.
Oh, yes, I apologize. So, yes.
That's fine.
Yes.
Just want to make sure that we're on the same page.
Yes.
Okay. You say after in South Fulton, they met at the Municipal Court CLE conference, right?
Yes.
You see that?
Yes, that's correct.
And then Miss Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief,
Good question.
Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so it says they met at Municipal Court CLE. The only other thing here says, that's what I figured when he was married. There's no response for me on that day. And then there's another response, I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so I don't have anything in that, is this accurate at all? I can show the court.
No.
It just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship
Okay,
at that time.
I apologize. It goes to the next page. I apologize.
No problem. Just
Yes.
want to make sure.
So,
that
no,
we're-
I see that now, yes.
All right, so that's what I just read is exactly what Ms. Merchant said to you in the text, right?
Yes.
Yes, that was in the test. Is it accurate upon further information? Yes, that's there.
And
Yes.
And what did you
again,
answer?
Since you have told us that you were speculating when you gave the answer that we went over with previously, on this one, you don't say, I don't know. You simply correct her by saying no, municipal court, right?
I don't know why I said that.
Yes, so she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right, and when you said it wasn't accurate, it was municipal court, you didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to I was answering the no municipal court, meaning when she said, is that accurate? It was to the municipal court and not magistrate court.
Okay, but you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true.
I don't know why.
That's not accurate. You simply said the only thing that wasn't accurate was municipal court should be there instead of magistrate, right?
So I was answering the question of, it was a compound question.
No.
And
Who
I was
prepped you for that?
answering the question of,
It was a compound question.
she wrote magistrate court and I said, no, municipal court.
Right, but it's not compound. It's one statement upon
Mr. Sadow.
information that believe. I'm sorry.
I know, that's okay. I know the feedback and the delay is complicates things, but I think you've adequately made your point here. I don't think we need to belabor it much longer. Let's move on to the next issue.
Okay.
Okay, thank you, Your Honor. Mr. Bradley, prior to coming into court today,
Did you meet with any
did
counsel?
you and your lawyer meet with anyone from the district attorney's office?
No.
Lie.
I mean,
Did your-
no.
Oh, whoa!
Not that I know, I'm aware of, no. I
Have
did
you
not
had
meet to
any-
anyone.
Sorry.
I did not
cut
meet
you
with
off.
anyone outside of my attorneys.
Did you have any conversation?
I did not.
Meeting, conversation.
I did not.
So you have not spoken, if I understand you correctly.
Have some
Prior to
text.
coming into court today,
Have
you've
some
not
cell.
spoken with the prosecutors.
Cell records,
No.
please. Please have some
Right?
cell records.
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No.
Fingers crossed.
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
There has not been any contact with defense or the state at all.
I think I have basically just one or two more questions.
Oh, I wish you had some cell
Why
records.
would you
although-
see the need to speculate when you were texting with Miss Merchant?
I don't know. I don't know.
I think we did cover that one.
Yeah, I
Mr.
just I was-
Sadow.
his better answer would have been, I was just trying to be helpful.
I think that exact question was already put to him.
Yes, it was. Judge is paying attention, which is a good sign, by the way. Sorry.
What would be the next one?
I'm trying to look. Let's go to 27.
I have to pee, everybody. I've been holding it in this entire cross, or this
Defense
entire...
Exhibit 27. Do you have that now, sir?
I do, sir.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Ms. Merchant and a text response from you, correct?
But the text response was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now is,
Yes.
is the email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
As it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time. Your
Same
Honor.
objections, Mr. Abadi?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, Defendant's Exhibit 27 is admitted.
All right.
Anything else?
Your Honor, I don't know. Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Ms. Willis existed before the contract in November 1st of 2021, that if you testified that you knew that from Mr. Wade, that would show that both Ms. Willis and Mr. Wade had lied under oath.
Objection.
You know that, don't
Question
you?
of opinion. Law.
I think that's going to call for an opinion on the credibility of another testifying witness. So I don't
Calls
think
for
that
a
would be
legal,
an appropriate
conclusion.
Then that's all I have, Your Honor.
Thank you, Mr. Sadow. Mr. Stockton.
Just briefly, Judge.
Did you
We'll
do
see.
it? Did you do it?
Mr. Bradley, do I understand from your prior testimony that Ms. Merchant sent you a motion to review prior to her filing it?
I don't know if it was a motion or an affidavit.
Cumulative answers.
Right. I'm going to give him just a little bit. All right, Mr. Stockton. Maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that
Objection. Asked and answered.
motion seemed okay to you?
Well, so you're referring to Exhibit 27, which, as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to
Yes, you
the
did.
email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And you're aware and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there, Judge, I promise you.
Okay.
I promise you.
Repeat the question, I'm sorry.
Yeah.
She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
Did you tell Nathan Wade?
The actual motion that she, that was sent?
Yes.
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been that she was working on it.
I don't
but
remember
yes,
what
I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Yes. Asked and answered.
Asked and answered and cumulative.
All right, noted. I think Mr. Stockton's getting to the next point, so why don't we just ask that one?
Is that correct?
Did you?
Why don't we
I thought you wrote.
combine that with the next question, so we're not having to lay bit by bit every single time?
Mr. Bradley, you knew that Mrs. Merchant was relying on your review
For accuracy.
to ensure the accuracy of that motion prior to filing it, correct?
Yes.
Speculation as to what he knew that Ms.
Oh,
Merchant
shut up
knew.
already and let him answer what he
I
thought.
overrule that. Mr. Bradley?
No, so
No, so let me
Once
get rid of the
again,
lie.
I was excluded from the footnote of that motion. And my review of it.
Absolutely
and
not
I
the
said,
question he
hey,
asked.
you need to add me back to the footnote because I did have a contract and I did receive $74,000.
That was not the question.
If I may help you out, let's talk just about that part of the motion that deals with the relationship between the District Attorney Willis and Mr. Wade. When you reviewed that, you knew that she was
Looking
that
for
Ms. Merchant-
accuracy.
No, I did not know that she was relying on me to
Not the question he asked.
for any relying on me for any accuracy other than what was put in there
Pretty much
If there
about the
was-
74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Ms. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate?
Do they not
We
have
were
like
discussing
one text
the
or email between him and
74,000
Bradley?
that was left out.
We've heard this answer over and over
Again, if I
again.
may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as
Objection
it
calls
relates to the relationship.
Objection calls for speculation. Wait, he's going to formulate an objection. Oh, the guy's waiting. How long are we going to get?
Repeat your question. I'm so sorry.
Oh no, he
You
does.
did
He does
not
this.
Inform Mrs. Merchant that there
Objection.
was anything patently false in that motion that you were presented with as it concerns the relationship.
Objection in
Because you did not see anything that was patently false, correct?
Objection, asked and answered.
There you go.
Cumulative.
All right, next question, Mr.
I've noticed something here now. He
And
says,
you didn't see
repeat the
anything
question.
that was
Then there's an
speculative in
objection.
there either, did you?
Asked and answered. Cumulative.
I know, sustained, Mr. Stockton.
I just want to ask you one more question. I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Good question.
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the call the only personal call that I had was with
Didn't say
Gabe
personal.
Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this, so.
That's all I got, Judge.
Thank you, Mr. Stockton.
Okay.
Mr. Durham, if you're still with us.
No question, John.
Thank you, sir. Mr. McDougall.
Now the question is, are they going to cross-examine this guy? Oh, well.
Good afternoon, Mr. Bradley. You have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have about the relationship between Ms. Willis and Mr. Wade is not privileged?
The court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I. That's
the only one. That's the only one.
Asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Silly question. Yes.
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougal.
There's a great meme in
Mr.
our
Rice.
locals.
Mr. Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a...
What just happened? What just happened?
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
That would have.
And
10
you
years,
recall
never
communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
Yes.
I'm going to object as to past and answered and cumulative.
Oh,
by
quiet already.
Previous.
Sure. We don't have to lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Okay. Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
Oh, good question. Okay, rephrasing it. Can you repeat the question? Objection. Wait for this. Did you tell her any lies? This is a good question because it's...
Did I lie to Miss?
No,
That's
I
a
didn't.
simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
I didn't lie. I was speculating.
Not that I recall. I don't recall.
Yes or no? No, you didn't lie to her. You didn't lie to her.
I mentioned earlier that I speculated on some things. I've testified to.
We were here. It was enthralling.
So I can't recall whether or not
I lied. Can't recall whether or not I lied.
No.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here.
There you
You're
go.
under oath.
Argumentative.
Shut up, lawyer.
Not ask relevant questions.
Mr.
Let's
Bradley.
find a question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection. Asked and answered
No,
twice.
no, let him
I
answer.
don't think he's answered it yet.
Let him
I
answer.
don't recall ever
Lying.
whether any of it was a lie or not
Ah!
this time. So
At the time
Sorry.
you were communicating with Miss
Write
Merchant,
this
you
one
were still
down.
friends with Mr. Wade, correct?
I don't recall if it was a lie or not.
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
Yes.
correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client, correct?
Yes.
I did
I
not
don't-
know that.
Okay,
So
see.
I did not
know why she
oh,
was doing
I'm
it.
sorry.
So as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's relationship.
So at the time,
So,
no,
let me
I
just
did
get ready
not.
to
I
lie.
knew that Miss Merchant was gathering information. That is correct.
Okay. And did you lie to her when you told her that the relationship began before
Objection asked
I
and
don't think we need
answered.
to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true the only thing that has really changed? Well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
Never. I don't remember if I said I don't
I
remember.
don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said,
I don't recall.
I don't remember?
Or I'm speculating. I don't think I did. Let me go flood through the papers. Let me just wait for my lawyer to think up an objection.
Yep, through the messages that I don't have all the messages in front of me, but no, I don't recall if I ever said. I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating. No.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Gabe Banks, correct?
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we are fraternity brothers. And so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection, asked and answered.
Oh, no, that hasn't been asked and answered today.
February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
Oh, objection, argumentative.
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Objection, argumentative.
Have I told lies about friends? I could have, I don't know.
Do you tell lies about your friends about a case of national importance?
Objection, that's to.
All right, overruled.
I could have, I don't know.
Oh my God, this is the
Mr.
worst
Bradley,
thing.
I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's
screen.
the next question, Mr. Rice?
Looking at you on the
No
screen.
further questions, Judge. I think it's clear.
Thank you, sir. Mr.
Oh,
Gillum.
argumentative there. Lawyer could have said something.
Good afternoon, Mr. Radley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Radley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent you.
Motion to
Do you remember
disqualify.
That was
reading-
sent on the 6th.
Excuse me, do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office,
I
and
saw
the
that
special
later.
prosecutor from further prosecuting this matter?
I don't remember if
Do
I
you
saw
remember
that.
seeing that in the draft that you read and reviewed?
Yes.
Oh!
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read?
Kind of. It's a little bit of a hint.
Yes or no?
This is good.
I read the title of what the motion was.
You
There
knew
wasn't
what
anything
she
in the
was
title
doing.
that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion to disqualify the district attorney and her office
This
and the
is good.
special prosecutor from further prosecuting the matter, right?
I'm going to object to speculation.
Shut
You
up.
knew that, didn't you?
Overruled.
Yes or no?
When she sent that motion, yes.
Okay. And you knew
The truth.
that the special prosecutor
set you free.
to whom she was referring in that motion
Was Nathan
was
Wade?
Mr. Wade, correct?
Yes.
You knew that.
Yes.
Because you read the motion, you said you reviewed it, correct?
Yes.
Yes.
And we're not going to go over all of the, number one, because we
This
don't
is
have
good.
time, and number two, the court wouldn't let me. But, but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right. Yeah, Mr. Gillen, you know, I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion, and he's had his response as to his opinion of how he handled it.
Okay.
I don't see that, again, this really being necessary to go through it line by line of what.
Well, a little indulgence, Your Honor. I'm not going to go, you know, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
You know, again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
that's the problem, and always ending up last.
It very much is. And next time asked, I'll reshuffle the order.
Well, you know, we did earlier with Mr. Wade, and then
I hear you.
I was kind enough, and then the court said we had to go.
Don't need to draw straws next time.
There we go. I'll go with that.
All right. Anything
Thank
else?
you, Your Honor. That's all I have.
Okay, good. That was good.
We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right. Could we add a spotlight to Mr. Kucherov? I'll let you know when we're able
Shine
to proceed.
that big spotlight right on him. Oh, Lordy. We're at, by the way, just so you know, over 15,000
Before he starts, can
on
I
Rumble.
take a 5-minute restroom?
Absolutely.
2 hours.
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also note for the record that we received a notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing.
Dude, let the guy go to the bathroom. He's got to pee.
To log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
No questions.
I don't imagine my questioning will be very long.
Okay. Well, let's get back in at 4 o'clock.
See if they're gonna come back to the sexual assault accusations. And now the dramatic zoom on the Seal of Georgia, 1776. Constitution, justice, wisdom, moderation. If only any of these people could live by any of these principles, the world would be a better place. Okay, so what I'll do is I'm going to take this out. Well, that's been somewhat uneventful. It's been good. I was hoping for more. What's going to happen Friday? I think that's going to be it for witness testimony. So Friday's going to be closing arguments, or summation as they call it. What a flipping liar. The judge gets it 100%. And bear in mind, we're dealing with credibility as to when the relationship started. Bear in mind, Yurdi, the very credible first witness of this case, testified as to when the relationship started. This guy's, I can't remember why I do not recall why I did not tell her. I do not recall. Glorious in its abject stupidity. So we got here from the Stu's Music Box. So Bradley admits telling lies. Fanny admits to campaign finance violations, taking money from the campaign. I missed that the first time around. Yeah, I took some campaign cash and I had it at my house. And Wade IRS fraud. Wow, just wow. Way to go, Viva from Edmonton, says Roxy. Thank you very much. I don't recall meeting Viva as we ate poutine, says Seize the Day. I remember that. Frou Featherstone says the National Bar Association told this guy not to talk. He knows better than to ignore the NBA's advice. Digimoto says this is magical. What a show. Anyone with a couple of functioning brain cells can see it for what it is. I just would have thought they would have had concrete text messages that were much more damning than the ones which we basically knew existed but were not admitted as evidence because of the raising of privilege. When is someone going to ask, where were you lying then or are you lying now? Those questions never get very far, Patriot, but look, I think the judge knows. How can one absolutely speculate, says Piano Dean. It's a load of steaming crap. I don't recall what I don't recall, says Pasha Moyer. And then Zerosopher says, when judged on screen, watch his face when bad answers happen. He doesn't like it. He's trying to keep himself safe from fallout, but it is in support of Fanny, and that's why he isn't stopped the other lawyer. We're going to see where this goes. I've made my prediction. They're getting booted. How is it not privileged? This was Tracy Bradley. Are you related to Terrence Bradley, Tracy? The question was the privileges to the start of the relationship with Nathan Wade. The judge said, no, that's not privileged. And then the other stuff, which was a broader, was in fact privileged, and they kept that there. But I also flagged that because I thought you might have been related to Terrence Bradley. If you are in fact related to Terrence Bradley, tell him I'd love to have him on the channel for an interview. Jeff, we got that. Thank you. Wade looks like he got caught with FANI in his parents' bed. TJM. Then we got to sure would be a shame if the sexual assault investigation was opened. Nudge, nudge, wink, wink, says Stick. I know exactly what you're talking about as to the threats they can have against Terrence Bradley. This is why people hate lawyers. So freaky. This makes... Oh, first of all, I've hated lawyers for a long time. And thank you for the hair. Yes. I actually brushed it yesterday, and today is just like the perfect day of fluff and not too greasy. Bradley was threatened with a Clinton helicopter ride. Yeah, we know about that guy. Super sticker Robin Montang. The president has a more reliable memory than this guy. Poor man, says WJRG. What do we got here? What did I just do? The president? Was he told before or after Wade filed divorce? So I put that out there. He would have said, I don't recall. Viva's hair is majestic. Thank you very much. I'm convinced he was threatened with a helicopter. I changed my mind, says Scott Gage. All right, now I believe I've gotten to all of these beforehand. What I'm going to do here is go over to Viva Frei on the Rumbles, and we're going to take some of these sweet, beautiful Rumble rants, top to bottom. Wilson Ann says, Wilson at Wilson Ann 273 is a scammer. Remove them. Let's see. Let's scroll down here. I did remove a couple of people who were clearly scamming. I'll have a look for that one in a second. I don't see it. See, this one here, I know that I've booted for this live stream. Though maybe I know that that's purely a bot. Okay, well, I'll get to the other one afterwards. Fiona is my biatch, says not everyone graduates at the top of their class. See Biden, for instance. These lawyers are pathetic. And then we got Fiona is my biatch, says Viva. Why can't this witness make eye contact? Oh, he's just looking at the screen, you see? No, don't do that. Don't do that. Jingle Jolly is now a monthly supporter. Welcome to the channel, Jingle Jolly, where everyone is thoroughly above average and anyone watching absorbs the knowledge and the humor and the insights through osmosis or transmosis. Ice Holden says, Viva, I think they're setting him up for impeachment because his testimony today differs from texts, emails, phone conversations. For sure. I'll tell you what I'm hoping. I hope, what's his name? Sadow. Sadow is Trump's lawyer who just filed that motion with the additional AT&T cell phone stuff between Fannie Willis and Nathan Wade. When he asked Terrence Bradley, have you had any telephone calls, correspondence with, X, Y, and Z? I don't know. Maybe they got other info with another AT&T request, or maybe they're now going to go verify that information to see if he flat out lied under oath, because that's a demonstrable thing. Although he would have to be tremendously stupid to actually go while, testimony pending and have discussions with anybody on the other side. But they're not very smart, so they might very well have done it. Viva, he said it earlier while, quote, mumbling, that he knew because his client told him, review your video for it. No, I called it out when it happened. He said it. Nathan Wade told me. And I said, boom. The chat said, boom. Constructionist. I do recall, but I ain't telling anything at y'all. This is painfully the stage of baffling with BS. Yep. W. Claxton says, can I get away with murder if I just forget doing it? No, but if it's classified documents and you're a well-meaning old man, no one will prosecute you because, they'll just acquit you. W. Claxton, if you can't remember why the conversation came up, it cannot be attorney-client privilege. Good point. I critical. Why haven't they requested Wade be sequestered while this witness is on the stand? They did at the beginning, and the explanation that the judge gave is that Wade is no longer under oath. They don't foresee him being called back as a witness, so it couldn't influence his testimony. I would have thought that Wade is a party to this in that he's a defendant being requested for disqualification, so he would have a right to be there. I don't know if they said that as well subsidiarily. Viva, go back to the video on edit. Bradley said earlier that he found out by his client telling him exactly. For sure, no. I thought I commented in real time when that happened. Fried Pie says, why does Willis and Wade have... What does Willis and Wade have on him so he'll keep protecting them? Well, someone brought it up earlier. Just the threat of another sexual assault criminal investigation. Remember, bear that in mind. They accused him of sexual assault, and it was just, ethics and why he left the firm. If they got Trump on a 25, 30-year-old fabricated hallucination from a batshit crazy woman, filed because of a law that just changed specifically so she could file that lawsuit, they can get on this. And by the sounds of it, he doesn't exactly have clean hands or clean whatever, because he allowed $20,000 that he had in escrow at Wade's law firm to be transferred to the employee who allegedly accused him of alleged sexual assault. So that would be why. That's what he's protecting against: criminal prosecution for sexual assault. Constructionist says, I don't remember, I don't recall, I don't remember anything at all. I got that. Viva, thanks for going live, Viva. I cannot wait to see what comes out of today. This was from 208. Well, unfortunately, it's not what we thought was going to happen, or at least not to the extent. Where's the female attorney for the defense, Anna Cross? Yep, I haven't seen her today. But we're here because of her. I don't think they want her back in the courtroom. Cooper True says, oh no, not going anywhere. The commentary is almost as good as the trial. And then we got Fried Pie. Did you hear about Jeff DeSantis, the Dem operative on FANI's DA office, direct ties to DNC Biden? Yeah, I don't know what more direct ties we needed than Nathan Wade meeting with the White House. But, dude, I haven't heard about that. I screen grabbed it. I'll have a look later on. Trefenia says, just want you to know that I found you during the Canada Truckers Drive-In. In fact, I have thank you truckers on the back of my van. And I got to figure out, oh, does anybody know a software, like an app that would allow you to do a real-time auction? Because I'm going to auction. I've got 2 of these stands, and I'm going to auction one of them for, I think I know the good cause that I'm going to auction it for, but what I was coming to get was this.
I want to talk to the truckers. I want to thank you.
Uh-oh. How do I stop this? It's back. It's back. Sorry.
You may proceed.
Okay.
Mr. Bradley, did you use any documents to prepare for your testimony today?
No.
No, I did not.
Only the motion that I already had.
Last time you spoke with Gabe Banks.
The day that, I don't have the date, but it was the date of whenever the phone call happened.
And you know his wife, Kyra Banks, works for the DA's office, right?
Tyra Banks.
Yes, correct.
When was the last time you spoke to Mr. Wade?
Objection.
I've spoken to Mr. Wade personally in
Personally? That's a weird...
2 years, actually, when I left the firm.
Oh, wow. Why would you say they were friends?
I never... my interaction with Miss Willis was never where I would pick up the phone and talk to her, or that she would... or anything like that.
So you didn't hang out with Miss Willis? You didn't have a personal relationship with her?
No, I never had a personal relationship. I mentioned before that I went to a dinner that was after she was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one?
I knew of her from she was in the DA's office and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
I'm gonna just
Yeah, compound question.
Cumulative, asked and answered throughout the.
All right, Mr. Kuchert, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with
Did
this?
the audio change? I'm only hearing it in mono
Give me a
now.
little latitude, I'll tie it right now.
Okay, you may proceed.
You got a contract from the office, not knowing or having a good relationship or a good working business relationship with Miss Willis.
Good point.
That's correct.
Why'd you get it?
That's because
Nathan Wade.
Wade steered that contract to you.
That's good.
I don't know how it came about, but it was presented to me at the office about the contract, correct?
That's a good point.
Who presented it to you?
Nathan
Mr.
Wade.
Yes.
Bam!
And he owed you money, you said at one point.
Ooh.
Say that again?
He owed you money, you said, at one
Owed you
point.
money at one point?
I don't recall saying that he owes me money.
Did he owe you money
Did
at
he owe
some
you money
point?
at one point?
Yes.
Not that I recall saying that Mr. Wade owes me or owed me money. I don't recall ever saying that.
I didn't ask whether you ever said that. I said, did he owe you, or did he
Ever owe you money?
money in the past?
Yes.
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
Yeah, the 2 years is
Contract was
2024.
in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than one last question, other than your attorney, who did you speak with today about giving testimony
Nobody.
in this case today?
I spoke to my attorneys, Charles Graham and BC Chopra.
And I have nothing further, Your Honor.
All right.
He did say that he owed money. He paid back for the
Check
credit
to make
card.
sure. Did Mr. Cromwell ever join us by Zoom?
Do you think? Oh no, he never had a relationship with. Okay, no.
All right, thank you. So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions as well. So turning it over to Mr. Abadi.
I have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
Judge, you want these exhibits?
Give him to the clerk. Well, all right. That lacked the explosiveness that we were hoping for.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today.
Yeah, did you get the one with the
I just wanted for reference to have them.
the garage clicker?
Okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes.
Have you showed them to the state?
I gave a copy to the state, but so these
Mr.
are.
Bradley, just hang out just for 1 second, just to make sure.
I'll give you all of them.
Oh yeah.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were in my folder.
Oh, is that from the hearing?
Yeah,
From on Friday? All right, well, thanks for returning those. Let me make sure.
Oh, all right. Well,
Okay, so I've got 23, 24, 25. Anything else in your binder? All right, good. Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I marked it, I think we're up to 39, surprisingly the state of
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay.
Text messages that weren't referenced today are confronted with
Okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right, how about, I'll just do this. Just, I understand the
all this procedural
desire
crap.
just to have the complete text chain, just for purposes of completing the record. I think that there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a court's exhibit, and only the exhibits, though, that had been previously tendered or referenced in testimony.
Page number them, and then
are relied on for
reference
making
the
any
numbers.
findings. But just so it's on the record, we have the complete text chain, should that ever be an issue for some reason. Any thoughts about that, Mr. Abadi?
My only thoughts are this is not the complete text chain. I was
Yeah.
able to
So take a screen recording of the video and scroll through it,
Okay.
seconds, minutes,
and then submit the
there
video.
are text messages I know that I saw that are not in what is purported to be State Exhibit 39.
Okay, all right. Ms. Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is My phone's an iPhone. His is an Android.
Screen record, scroll through it all,
They
and
had a
submit the
system
video.
To get all of my texts, they can have every single one of them.
We can definitely do that.
Your Honor,
Yeah, Mr. Rice.
text that she's submitting now and tendering it to evidence.
This is so annoying and boring.
Specific parts of the conversation. The entire text chain is a continuous conversation, so 601. Those particular parts, given the witness's testimony, should be admitted to substance evidence of prior and consistent statements with his testimony today. It would be up to the government or the state if they then want to introduce the rest of it.
Yeah. Sure. I think that's
Yeah.
a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior and consistent statement for impeachment. And some of them were. But apparently some of them were not.
I'm taking those out. So it's gonna, I'm taking out the ones that they said.
Yeah, this is boring procedural crap. This is what's insufferable about court.
It just makes it more confusing.
This is all just a question of how to file the
All right, so we have a
text
newly marked-
messages that were referenced.
Newly compiled 39. Let's see what the state thinks of that one.
Oh yeah, I found a way out, man. And then everyone's got to be so artificially
Regardless,
polite
if
with
that's
each other.
now what is being discussed. Again, I don't see a need for Mr. Bradley to be here any longer, so.
Get him out.
Excuse him at this point.
Tell us what happens on Friday. What's the schedule? It's going to be closing arguments unless there's...
Take care. Yes, that's right.
You did good, Terrence. You saved your ass. Better leave the state. Maybe leave the country. Okay, so yeah, this is so no, we're basically done for the day now. I'll have some comments that questions that I'll get to, but in as much as I can answer them, we're done for the day. And then the only question is, we're coming back March 1st, and the only question is, are there other witnesses, or is it going to be summation or closing arguments? No, but you can't really weasel around. I mean, other than saying, I don't recall, that you could answer that to everything. Oh, did you say this here? I don't recall. If it says it there, I said it, I guess, but I don't recall. Oh, yeah, and but he did specifically say, oh, he just gave everyone COVID. Oh, shoot. I can't believe this judge is not wearing a face mask. That bastard. I do like the judge, and I think he's going to get it right. And that girl, by the way, if you see in the front there, she's now just dictating into a microphone everything that's being spoken so they can transcribe the hearing.
So where are we with Defense Exhibit 39?
It might be helpful if you looked at them so you know what we're talking about, but I confronted him with all of these. Great, I know. So, Exhibit 26, I put in so that it made sense, so you could read it. You know when you're reading a text and it's a conversation?
Sure.
They're upset that they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
What is
I
it?
showed him, and that I showed him today. So there were a lot of follow-up questions on it, and so I realized, okay, well, they should just be in the record because other people are referring to my texts, and they might as well just be in the record. And he authenticated all of them.
All right.
So,
And Mr. Rice?
Not just in the record, Judge, they should be admitted as substantive evidence because they come in as prior and consistent statements.
My GoPro.
Okay.
Okay, good.
All right. So
It's
to that
easy
end,
enough.
Mr. Abadi, is there a particular text message in there you think was not authenticated? I
Oh,
understand you're
shut up
saying,
with the
well, maybe
authentication.
One of them's
They're
already
going to
been
plead
admitted,
it.
So, but otherwise, just having a omnibus. Here are all the relevant text
And-
messages exhibit. Is
and
there
page number them so you can reference them in
any other
arguments.
kind of objection like that?
Yes, because he didn't authenticate that all of the text messages were from him in between.
Oh, bull
just
crap.
the context of-
Weasel.
I think that's the problem. When you don't, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant. Really, all the information should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then, so there's a few text messages from September, and then we jump to January. Ms. Merchant has determined that jump in between is not relevant. That's not appropriate. It's for Your Honor.
No, but, oh, well, that's bullcrap. She offered you all of
I
it.
can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message.
She offered all of the information to you.
Admit that she didn't confront the witness with would be my objection, but only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant.
So give it all,
So,
give it all, and if you find something relevant,
Didn't
ask.
she just try to do the full chain
Yes.
as an exhibit just
Yes.
a moment ago?
No, we don't have the full chain.
That's not what this
Full
question
chain
was.
is
Did
text
she
messages
offer
that
it?
begin in September and continue down. That's not contained in that entire
The
package.
rule
They're
of
on her
optional
own.
completeness.
If you'd like us to do it in a tracker, that's just that chain.
That's
we're
not-
happy to do
Ms.
that
Merchant,
technology.
and then I'll, Mr. Gillen.
Yeah, not a problem. And I offered that when we were here before, and I was told we didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You
together.
can just hand them to me.
Someone said I'm behind. How far behind are we?
I can read them. And while I'm reading them, Mr. Gillen, what did you have to add?
Brief point, Your Honor. Apparently, Ms. Merchant has
Okay.
allowed.
Maybe I'm a minute behind at most.
Screenshots of what they now contend would be the larger perspective on. and-
Oh, this is so painful.
The rule of completeness, but it's their job when something is admitted, that if they have an objection because the context is not appropriate, they then move. The state should move the rule of completeness to the admissibility of the other emails chain that they had. So the real issue here is their failure to comply with the rule of completeness once they had the material from the last hearing that they took screenshots of.
Well,
Yeah,
isn't that what he's doing now? Because
Well, but he could have done. He's complaining about admissibility
I
now.
don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in, and they objected to that. Then she wanted the segments in that had been, the witness had been asked about, and that's what she's trying to do. My point is that if they're, at the time of frankly, of
See if I can get a better audio from the court.
completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on Ms. Merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act.
Oh, hold on a second. Guys, I'm going to do this. Hold on. I'm going to stop and switch it over here. Give me 30 seconds. Not here. I think it's this one.
Be complete, that's on them.
This one's
Sure.
Not
better.
on Ms. Merchant.
All right, Mr. Abadi, last point
much
here.
better.
I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one
Okay, here we go.
part of the text message to then send to myself before Miss Merchant demanded
This
her
is a
phone
load of
back.
crap. She
So I did not
offered
have
all
the
of it. This
opportunity
is
to
so
screenshot
stupid.
every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information.
Take
So
a screen video
you
of
don't
it
have
all.
the complete packet, and there are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense
Oh,
counsel.
shut
to
your
confront him.
weaselly mouth.
All right, I don't think we need to get back and forth any further. Ms. Merchant, you said to print
Take
out a
my
complete
phone.
chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you the chance to do that, and you can follow up by email with that exhibit. It would be the complete chain without
There you
any
go.
deletions or
The
removals, and
weasel
we'll have
wanted to
that marked as
not allow the
Defense
evidence.
Exhibit 39.
Judge, I
And-
have got to respond though. In court
There you go.
Friday at 1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him, "Do you want any other screenshots? I have nothing to hide. You can download my phone if you want." So
All right, we're done.
Good.
Okay, so I'll wait back to hear from y'all on Exhibit 39. And
What happens Friday? What happens Friday?
is there anything else to take up before we discuss Friday?
There you go. Okay.
Just
I got to tell you
throwing it
that
open to the
lawyer
floor.
was trying to say
Seeing none. I believe
he said
I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has
Okay,
there
so it's
been
arguments.
any decisions reached on that?
to determine that,
Okay.
and I can email the court when we're done with that. But we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
or who pleads it.
Time limits.
Yeah.
That's large.
Yeah.
gonna be all day
That's-
Friday.
That's the idea.
You can tell us what that'll be, and then
Well, I'll start with, what is it that you're asking for? And we'll start there. It's kind of curious.
Well, I don't think
Yeah.
we can answer that right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give each defense counsel a specific period of time. Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can. We can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally said to reopen the evidence as to another witness. I only got to read it very briefly. Or I don't know if that was just saying in the alternative, we'd like to reopen the evidence. I don't know, maybe someone can clarify that. But my thought there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today is that both parties, any party rather, can make whatever arguments they want based on a proffer. Any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that the proffer is going to make a material determinative point, we can reopen the evidence at that point. But just the bottom line is on Friday, I do. The intention is that we're still sticking with argument.
Okay, good.
But the parties are free to address some of these issues that have been brought up post-hearing if they'd like to.
Your Honor, excuse me.
Uh-oh.
Sorry.
Let me start with Mr. Sato.
I'm alive and well with a quick question.
All right.
That suggests that we do not have to have a witness present on Friday for the cell phone record, correct?
That's right. Friday would just be argument, and counsel can proffer why they think it's significant. And if once I've heard the law and the argument of counsel, I decide that that is going to have some material bearing on the outcome, then we can reopen the evidence and have it properly admitted and authenticated and subject to cross-examination.
Thank you.
Okay.
Okay. Ms. Merchant.
I just wanted to know if the court wanted us to focus our arguments on anything in particular. Any questions you wanted us to try and answer?
You do what you think is necessary.
I think what I'm more likely to do is more along the lines of what I suggested before, is give you all a time block and you use the time however you think is more effective, what you think is your strongest argument. I don't, a lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you. Mr. Gillen?
Thank you, Your Honor. I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that, that would be the time for that argument as well.
I consider that part of the disqualification.
Sure.
I thought we had scheduled hearings on the murder.
No, I mean, I talked about that and then things evolved. So we didn't actually send out a notice adding any other motions, but we do need to. We have some trials starting next week.
It's
the next
not
2
a
weeks,
ruling.
we've got
It's not a ruling
some of our
on Friday.
homicide trials already scheduled. So I'm going to be following up with you all
It's going to be arguments.
schedule the rest of the pretrial motions that we have.
He's going to draft his ruling.
We have on Friday, it'd be 1 o'clock on the issue of disqualification.
That's right. All things disqualification. Anything from the state or any other defense counsel?
Nothing from the state.
All right. Thank you all. All right. We're off the record.
Okay, well, that was cool. Not as blockbuster as we thought, but Terrence Bradley is he's not lying, because equivocal statements can't really be deemed to be lies. They're just, I don't remember. What's going on here? Refresh. Do we lose the feed? Is it over? Brickhouse Nutrition. Hey, I know this thing. Okay. So that's it. Field of Green's got a little refresher reminder at the end. So that is it, people. That's the day. All right. What did we learn? Let's close this up here so I don't have to worry about the sound coming up. There were some super chats and some Rumble rants and some tips in our vivabarneslaw.locals.com community that we're going to get to. What did we learn? Bradley's a bad liar. Super sticker from CR. Thank you. Hey, I don't recall works for testifying before Congress, so why not here? His memory is so bad he could be president, says Mr. Buttons. Then we got, dude, you are the Tony Romo of the courtroom, and he's making $20 million per year for his commentary. Tony Romo. Am I going to be an idiot for not knowing who that is? Football quarterback. Tony Romo commentator. Well, then, yes, I am the Tony Romo of the courtroom, sir, and I'm going to screen grab that and refresh my memory to make sure that I demand more from the YouTubes and the Rumbles. I'm joking. Did he just say he took the court papers home? Is that allowed? That's just exhibits. The exhibits were already filed as far as I understood, but it's a printout of an email, so not a big deal at all. It's not like he's doctoring evidence or anything like that. Let me see here. Hey, Viva. Be cautious shilling gold. These companies are very scammy. Transferring the retirement account into gold is a major red flag. Thanks for everything. Well, thank you for I'm going to ask the question. Thank you for the super chat. Viva, isn't it possible that Trump team's lawyers have the phone records of Bradley already? Or can they use his testimony to subpoena them for impeachment? They're asking those questions a lot. I noticed that they're asking those questions a lot. And so I don't know when would be the best time. Like, you presume they don't have the information right now. Otherwise, they would have contradicted him on the stand immediately. If they discover information that confirms that he was lying on the stand, a motion, what is it called? Order to show cause, motion for contempt. Ask him if he's seen them with Yurdi around. So they could, in theory, use that information or acquire that information later. And then what? I mean, perjury would be the number one. Contempt, maybe. This is from Robert. It says, disqualification isn't their fear here. It's the dismissal of the indictment and seeing how bad the corruption is in the attorney general's offices. Yeah. And if they, bring in a DA from another county and that DA comes in and says, okay, well, we're not dismissing the charges. We'll just disqualify FANI and Nathan. You got to get another district attorney and corrupt prosecutor willing to take these charges. And so the whole reason is they might have only gone with FANI and Nathan Wade because these are the only two nincompoops dumb enough to do this. Governor Barnes didn't want to take it up. Sure, it wasn't his hourly rate. He's got mouths to feed and he's 100 years old and wants to enjoy his retirement. Also probably doesn't want to destroy his reputation over a bullshit prosecution like this. So the judge has potentially seen that knows more. He must consider it. Digimoto, not sure what you mean by that, but subpoena Willis's guards and Wade's ex-wife. Oh, that would be so good. All right, and that's it for there. Now, let's bring on the Rumble. There were a couple of Rumble rants over here. Oh, yeah, we got in the House. No, you let the witness testify and then impeach him later. Like when someone is being deposed, just let them talk and dig the hole deeper. You can't impeach them if they've been released from their subpoena. So you might be able, if they lied and you get, damning evidence that he was on the phone with Wade or whatever, you could go for contempt. But I may be wrong about this. You can't impeach them once they're you can't impeach them once they're no longer under oath, and you have to have a damn good reason to call them back. So maybe they can find something based on the answers. Me to the G says, can we expect a motion tonight? I'm trying to think of what motion we would be able to get. Like, they find a new witness. I'll have to think about that. I mean, look, this is Friday is scheduled. They're going to be all-day arguments. We'll see how they divvy it up. That was from me to the G. Rocco Horse says, I seem to remember saying it was a bad idea for her to hand them her phone when it was the only copy. Just naive boomers. If she has not already screen recorded, scrolling through all of those texts, emailed it to her, and uploaded it to the interwebs unlisted as a video, she is in fact a boomer. Circus 2024, only Fulton County can pitch this tent, says Silverfest. Ha. And then we got PS34 is now a monthly supporter. Welcome to the channel, PS34. And now, when I say welcome to the channel, welcome to vivabarneslaw.locals.com, where everyone is above average. We've got S. Laird in the house over at vivabarneslaw.locals.com, who says, Viva, are you staying on YouTube all day? The chat is stalled here, so I'm getting off. Yeah, with these, well, this was my second stream of the day in any event, but no, these lives, it's stay on both because it's the best way. It's the best way to drive the traffic to vivabarneslaw.locals.com and Rumble. By the way, did I mention that we're still on Rumble? Yeah. Oh, hold on a second. I just lost what I was getting at there. Where was I? Here we go. Okay, we got Charles Markham says they should look at the level of calling and texting after the relationship ended and compare to before. Well, I mean, you can presume you know the answer to that. It's not going to reveal anything. What's great? They confirmed a massive amount of calling and texting before the contract when they said they didn't have a relationship, a romantic knocking boots one. Michigan Winter Days says, this has got to be Ashley Merchant's best year as a lawyer. Took a BS case and went on the offensive, which exploded in the prosecution's face, exposed so much to everyone. She still hasn't accepted my invite on Twitter, which I find very insulting. I say, what in the what? Okay, so that was good. Yeah, no, she's proven herself to be audacious and skilled. So we got, hold on, this is going to be, okay, then we got MSM. Oh, MSM CPA says, will Trump attorney question him as well? Yes, we saw that. That was Sadow who did it and did a good job. Cliff Norman says, Viva, what say you? Wade and Fanny are trying to stay out of jail and disbarment. Appearance of an unfair prosecution has probably been established. I think so. But I think it's been established everywhere, even in New York. In my opinion, Bradley is probably being blackmailed with something awful. It's not even Mandalici. It's right there. Sexual assault. Blackmail him with a criminal prosecution. We know that they would prosecute Trump for nothing. They've got definitely more in terms of sexual assault allegations against Nathan Bradley than they did of RICO against Trump and his attorneys and counterparts. So yeah, they've got something awful. I think it's sexual assault, and they threaten him criminal prosecution. You'll go to jail. Forget your 20 G's that we took out of your escrow. Also, read Breitbart's article about Jeff DeSantis for Fannie's DA office. 1,000%. You're not the only person been mentioning it. JAsh62 says, somebody missed a very important question. He made a point to specifically mention that when Wade and Willis met at the conference, he was, quote, married. Why would he specifically mention that if it was just an off-chance meeting? Now, I think he was just trying to say, like lending credibility to the fact that it wasn't a sexual relationship at that time because he was still married, unhappily so. All right, we got Paracleric says, not till after the trial, Viva, says I think that might have to do with the criminal charges. Gypsy Muse. Okay, I am not really clear on what we accomplished over the last 3 hours except wasting taxpayer money. They were allowed to ask, okay, so we didn't accomplish much because I don't think we got anything new out of today that we didn't get previously. The judge looked over the text messages between Merchant and Bradley, where he was invoking privilege as to questions about the text messages relating to when the relationship started. And the judge said, I've looked them over. There's nothing privileged in there. And so you get to ask those questions on that specific issue and nothing else, which gave Nathan Bradley, when did the judge order that? Totally brain farting here. Oh, yeah, no, that was after. So that was a week. It'll be 2 weeks on Friday. And so the judge said, look, you can ask more questions on that. His knowledge as to when they established their fornication relationship. And he had a week and a half to prep. I don't recall. It was speculation when I gave you that definitive factual detail. Unsolicited. I was speculating. Had no basis for even knowing why I said it. I don't even know why I said it. I don't even know why I didn't say I don't know because I've been saying it so much today. So what we got out of it is he's a flipping liar. Okay, he's a flipping liar. What we got out of today is his explanation for having offered a very matter-of-fact, specific detail that was unsolicited. He now says he didn't have any personal knowledge of it. He has no idea why he offered that. What was the word he said? Speculation. No idea why he offered that speculation and that he had no personal knowledge of when they got into their relationship. That's it. So what we established today, he's a godforsaken liar and a joke. But maybe they won't go after him criminally. Although they still will, because what the hell was he texting with Merchant, knowing damn well what she was looking to do with that motion, which was quite clearly specified in the header. It's not on YouTube anymore, not since... Oh, I would never give YouTube a cent. It's not on YouTube anymore, not since Google bought it, not a typo. Go ogle. Okay, so that's what we accomplished today, Gypsy Muse. And I think it was a fun day. I thought they would have had like actual text messages or emails between Bradley and Wade. And I'm curious as to why... I'll ask Barnes, or maybe I'll ask Gouveia because he'll probably know better. But like, why, when they subpoena him, they say, "Come testify, bring with you certain documents." Subpoena duces tecum. Why wouldn't they ask for correspondence between Wade and Bradley as relates to? Oh, that's it. I just had it. This is the motion that they're going to have. Call back Bradley. Issue a subpoena duces tecum, to bring with you documents. Now that we've established correspondence between Bradley and Wade as relates to the date of establishing the relationship are not privileged, get some emails, get some text messages, all of them. Bring with you any and all text messages, emails that relate to, pertain to, or confirm the date of the relationship between Fannie Wade and Nathan Wade. Fannie Willis and Nathan Wade. And I don't think he would get to so easily claim solicitor-client privilege, because now that they said, well, it's not privileged communications as relates to the date of the relationship. They might argue that was only between Merchant, his text with Merchant and Bradley. But make the argument. We only want text messages that would confirm the date between Wade and Bradley. And I think I'm surprised they didn't ask for that in the first place. I don't want to know everything your lawyer-client privileges. I want late night booty call text messages. Oh yeah, I just got back from Fanny so I'm so tired. I left at 4:45. I don't know if you heard, I got there at 12:35 and we made nookie all night long, and then I left at 4:50. I'm so tired. So tired, Bradley. He's going to say, we haven't spoken in the last 2 years since I left the firm. He left in 2022, so there could have been an overlap. That's what I would do. That would be my motion, if anybody's watching this. We'll see if that happens. I won't hold my breath. Oh, so that's it. And that's it. We'll see what happens. I'm going to bring this up because this is funny. I got an ad for this. It was Obama. Our greatest president of all time, Joe Biden, needs your support, from American Shitbag. Then we got All Good Guy says, fuck Joe Biden. And then we got our president, Joe Biden, needs your support, Biden 2024, from American Shitbag. I think that's a troll, guys. And then okay, then we got that. Okay, this message was brought to you by Joe Biden. Joe Biden supports. Hold on. We are totally doing something funny right now.
Good to see you. Sorry, under the
Oh, I can't get the...
circumstances.
You know what I can do, however? I can go all the way to here. See my beautiful face. There we go. And I'm going to screen grab this, you see? And I'm going to go post that and say I got a smashing endorsement from none other than Joe... Oh, I can scroll back out. Here we go. Look at this. This is looking good. Now we're got it. Like this. Rants. Screen grab. Viva Frei. Bada bing, bada boom. Up. Let's go down here. Bada bing, bada boom. There we go. Got a smashing endorsement from the best president who could ever remember that he was never president. All right, people. So that's what happens. What day is it today? It's Tuesday, Wednesday. I seem to recall I have scheduled things this week. I've scheduled a podcast for Thursday evening, and then I'm scheduled to be on with Dr. Drew Thursday evening and Kayla Pollock, talking about her situation, her lawsuit against Moderna. I have to make sure I don't forget things. And that's it. Go back to vivabarneslaw.locals.com. Viva, what about the cell phone data? Laird456. So what's going to... That is now an exhibit. Did they not have to have the expert testify? Are they going to have a response to that? Laird, it's a good question. What happens now procedurally with that? You had them file that as a supplemental exhibit, and presumably, in order to admit it as evidence, you're going to have the expert testify, and then presumably they're going to have to find a way to contradict. I'm not going to answer that question right now because I don't know the answer definitively. Life is hard. It's harder if you're stupid. Paracleric meme. FBI used it in Washington. Doug LaAfan. Okay, then we got Patty F. Weber says, I thought the fraternity brothers, twin brothers of a different mother, would have a wink, wink, elbow move type of text about booty calls with FANI in 2019. Probably. Ooh, yeah. Okay, and we got, somebody missed a very important question you made. Okay, no, I got that, Jay Ash. So that is, that's all that we have for the day, people. I think it was a very fruitful day. It's 4:40. Might still have time to go fishing, people. Catch a fish. Or get some sunlight, because I've been sitting on my butt. When did I start sitting on my butt? At about 12:15. Yeah, I'll go stretch out my legs. Everybody, stay tuned. All good stuff coming. Let me go to the chat in vivabarneslaw.locals.com, see if I don't miss anything. No question. Thank you, says Maria36. It is not expert testimony. The judge said to give him a proffer and he'll decide to accept it or not. Thank you. Okay, well, that is the answer. Yeah, but I'm curious to know how they're going to undermine that. Yeah, okay, so they're going to proffer it and the judge will believe. Okay, thank you. And then we got Tupac Amaru says, they are going to proffer, and if the judge believes that information will move his opinion, he will reopen it. Okay, fantastic. Viva, is anyone covering the 29th Amos trial? Well, it's not going to be, this is from Gypsy Muse. From what I understand from Barnes, it's not going to be broadcast. The question is going to be whether or not there's going to be a live tweeting lawyer there. It's in Pennsylvania. See who we know in the district, in the area. We'll see. One thing's for certain, Barnes is going to be there, and maybe we can do a follow-up immediately after. Patty F. Weber says, thank you, Viva. Sitting on the fanny, says Dougal, a fan. I get that one. Isn't geofencing admissible? Since cell phone location data tower pings are available without a warrant, apparently it is. And then if necessary, expert witness can testify when reopened. Okay, good. Everybody, it's been wonderful. I'm going to go stretch the legs and actually maybe try to cast a... Do I try to like fill the next 4 minutes so that we can end on 3 hours on the nose? The answer to that is going to be no, because I got to go snip and clip some highlights from this now and then get ready to do my evening summary for the people who don't have 3 hours to sit on their fannies and watch what was mildly uneventful, but nonetheless fantastic. So we're going to end it. Thank you all for being here. Rumble, Viva Frei on Rumble. Thank you all. I can leave the chat open a little bit on Rumble. Oh, that's what I'll do. I'll leave the live chat going on Rumble because there's still 12,000 people in there. Cecilia14 says, fish for my dad, Viva. He loved to fish. Cecilia, did you guys see the... I'm going to do that. I will take that as an order and not a recommendation. Did I post a picture of the fish that I caught earlier today? Here it is. This is the fish that I caught yesterday. I bought a new fishing rod. A rod, not a reel. Now, I'm not gonna pretend that I'm not a little superficial. I love the fact that the rod had an American flag on it. I love the fact that it said, "In God We Trust" on it. And I love the fact that it was made in America, and I believe it was Missouri. And I caught a fish, a beautiful fish, off the second cast. So, Cecilia, I'm going to go abide by your command right now. And I'll end this. Thank you all for being here, and I'll see you tomorrow. That's it. The fish wasn't that big. And no, that's not a fly rod. It's just a bait casting rod, because someone rightly pointed out that I was fishing with a... No, sorry, that's a lure casting rod, and I was fishing with a bait rod on a spinner, which doesn't make for nice, smooth casts. So I went out and got a lure casting rod for my spinner rod, and it casts very smooth, and it's beautiful. So all that to say, I'll leave the chat open on Rumble, Viva Frei. I'll leave the chat open for a bit on vivabarneslaw.locals.com, and I'll try to pop in there when I go fishing. And I'm going to end it on StreamYard, so that I can now save the file, snip clip, and I will provide an evening nightly summary tonight. Sure as sugar, people. Get out and go enjoy whatever's left of the day, and thank you all for being here. Peace out, people. Booyah.